Good morning. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Stephen T. Northcutt, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Good morning, everyone. Welcome to this remote session of the Second District Court of Appeal. If you represent the appellant, know that you are entitled to reserve some of your 20 minutes for rebuttal. And if you'll let me know when you come to our virtual podium how much time you want, I'll try to give you a heads up when we get to that point. So the first case is Zinco versus Department of Highway Safety and Motor Vehicles. Okay, I see that we don't see you, Ms. Jones. There you are. Welcome.
Thank you, Your Honor. My apologies.
Oh, no problem. At some point during this OA, I guarantee you I will start speaking with my microphone off. So it's normal. Okay, Mr. Isaac, you're up.
Thank you very much. Good morning, Your Honors. May it please the court. My name is Ilan Michael Isaac, and I represent the petitioner, Eugene Zenko. Your Honor, I'm going to ask for a 5-minute heads up, if that's okay. I'm before the court this morning on behalf of my client. It is a petition in second-tier certiorari from a driver license hearing. I recognize that second-tier certiorari is a very limited level of review. Oddly enough, I do believe that we are entitled to second-tier relief, not only because the circuit court impermissibly reweighed evidence and made its own factual findings, not made by the hearing officer and certainly not supported by the evidence, but the circuit court failed to apply the correct law. And in doing so, there's a fairly recent case out of the first DCA called Taylor that I provided supplemental authority to the circuit court. They struck it. But nevertheless, instead of relying on Taylor, the circuit court cited to the case of Dermio. So I believe that we're entitled to certiorari relief in both instances, on both grounds. In looking at the particular facts, as I pointed out in my petition, the hearing officer made findings of fact that were specifically found on page 3 of that final order, and those facts were the petitioner was very confused upon waking up, had difficulty responding to the request for him to roll down the window, and had dexterity issues trying to accomplish rolling the window down. The petitioner
Mr. Isaac, can I interrupt you?
Yes, ma'am.
Because I think the facts, you both laid them out beautifully, and I think they're out there. Help me out because of the second-tier cert, and I know you briefly addressed it. Let's focus more on that. Let's just assume that the hearing officer was totally incorrect in his findings. Let's just assume that the hearing officer, based on the facts presented, shouldn't have come to the conclusion that he did, that, that there was no, let's just assume that was the case. Then it goes up to second-tier, it goes up to the circuit court, and the circuit court basically, in this case, they go along with, what is it about when you said it was a departure? What did the circuit court do in its appellate capacity that gives us, because second-tier cert, like you said, is an extraordinary remedy. So even if we assume factually, legally, you are correct, how do we get around the very stringent requirement of the second-tier cert? So
the circuit court made a finding that my client voluntarily opened the door. The hearing officer never made that finding. The hearing officer found that my client just opened the door. In fact, in his order, in one place, he said the petitioner eventually opened the door, and then 2 pages later, during a discussion of one of my motions, the hearing officer said the petitioner on his own opened the door. The petitioner didn't, the hearing officer didn't say the petitioner voluntarily opened the door, just on his own. And there's some context to that. And that's why I said in my petition or in my argument, voluntariness is not synonymous with on your own. The Merriam-Webster definition for on your own means without aid or support. The facts are unquestionable. The officer kept knocking and knocking and knocking. He kept ordering my client to roll down the window. My client was having difficulty doing that. The hearing officer, when he makes the finding that my client had dexterity issues, but on his own opened the door, it's in response to the fact that he couldn't on his own without aid or support roll down the window, but he did open the door without aid or support. So the context in which that statement is made by the hearing officer is not voluntariness. So in the circuit court order, the circuit court misinterpreted that phrase on his own. And they came to the conclusion that that means it's voluntary. They made a finding of voluntariness. They're not permitted to reweigh evidence. They're not permitted to make factual findings on their own. That's impermissible. That's impermissible reweighing of evidence. And that's exactly what the circuit court did.
So by virtue of the term on his own, it could be interpreted two different ways, not on his own that he did it because by his, willingness on his own, which would equate with voluntariness. You're taking the position he did this on his own because he did not need assistance when he did ultimately open the door. Is that what you're saying?
My argument, you're correct, but my argument is supported by Merriam-Webster. The definition, the context and the use of the phrase on your own is synonymous with no aid, no support. And as this court knows, words matter. When the legislators pick the wrong words, they may have intended one thing, but the words have a different connotation. The hearing officer, who by the way is a lawyer, if he wanted to make a finding of voluntariness, he would have done it. He would have said, the officer asked the petitioner to roll down the window, but instead he voluntarily opened the door. The hearing officer never came to that conclusion, never. And that's why I'm saying in the context of reading that one statement on page 4 of the order, where it writes, after Officer Barlog knocked on the window, petitioner was very confused upon waking up and had difficulty responding to the request for him to roll down the window. Petitioner also had dexterity issues trying to accomplish rolling down the window, so he, on his own, opened the driver's side door. The context there is he's having difficulty, he needs aid, he needs support to roll down the window, but he doesn't need aid or support to open the door. The context of the meaning that consistent with Merriam-Webster is right there. When you look at the statement in total, the circuit court just misinterpreted, and they came to the wrong conclusion. They misinterpreted what that statement apparently means, that it's voluntary. The hearing officer never made a voluntary factual finding, and the circuit court on appellate review and first-year certiorari was certainly not allowed to make its own factual findings now for the first time. That is impermissible reweighing of evidence.
Mr. Isaac, looking
Yes, sir.
at Taylor, is not that case easily distinguishable from the instant case in that in Taylor, the operator's vehicle, the ignition was off, the car was not running. And here the car is running, which gives at least the element of being in actual physical control, being present. Isn't that an element of DUI, being in actual physical control?
Oh, absolutely. But
Right.
with all due
So
respect,
he's
I
in
think,
actual physical control when the officer comes to the window and knocks on it to make sure that he is capable in light of the hearsay evidence that the dispatcher received, if we can call it that, to go there, to make sure he can operate this dangerous instrumentality. So he rolls down the window. Does he not then indicate in the officer's testimony he got a smell, the odor of alcohol?
well,
And
with
he
all
asked
due
the
respect,
gentleman to step outside the car, and we have staggering. Aren't some of the reasons for probable cause being met, which would then support a suspension?
well, with all due
What
respect,
does it
Judge,
matter whether he voluntarily or involuntarily rolled down the window? I guess is my point.
well, with all due respect, Judge, I don't mean to cut you off.
No, you're fine. Please, I
Okay.
wanted to hear your answer.
So What you're talking about is whether or not my client who's sleeping in a lawfully parked car can have interaction with law enforcement. That's not the consideration here, because the evidence was that this was a community caretaking function, consistent with Katie versus Dombrowski and its progeny. The criminal investigation that you're referencing has to be completely divorced from any community caretaking function.
So the officer testified he was doing a wellness check, basically.
Correct. That's right in the report.
And once he got the surfer signal, at that point, there was no reason to proceed with the wellness check.
And
Well,
in
it's not-
fact, didn't he go like twice? So if in
There's-
fact it was just
there's-
purely, even if it's purely a wellness check, first time he gets that signal, and then he did it again, and at that point he gets a thumbs up, like I'm A-okay. So if it's purely a wellness, at that point that stops. So
I agree
anything
with you. And
after,
that's,
so anything, so let's just, if that's the assumption that we're making, then from that point, anything afterwards, the officer, if it's pure wellness, he gets not only the surfer, which, in the surfer, I didn't know that the surfer means I'm A-okay. I just thought, hey, cool, I'm here,
So
But
once he says to the fellow to roll down the window, that's a
Then-
detention.
then that split second is your argument is after he gets the surfer, then the second time with the thumbs up, then at that point he should be done. The officer should have left because he's A-okay, but then he went further, and then we said to roll down the window.
I don't want to cut any of your honors off.
No.
Okay.
I'm just.
so-
Why don't we argue your case for you?
So I agree. And in response to Judge Casanueva, the Taylor case talks about the justification of the community caretaking function, but the moment that the reason, the legitimate concern for well-being is resolved, that's the end of it. So yes, so my client makes a gesture like a surfer gesture, which maybe could be interpreted in a number of ways. It could mean he's okay, but it could mean other things. But when he gives a thumbs up, everybody on this panel knows, as well as my opposing counsel, nobody's going to misinterpret a thumbs up. My client said he's okay, and consistent with Taylor, that was the end. But the officer keeps knocking and he keeps asserting himself. And that's why I made the argument that Dermio was not the applicable law. And actually, I see this case perhaps as an opportunity for this court to discuss the limitations of Dermio, because while I respect the ruling, whoever litigated Dermio, unfortunately, didn't raise the nuances that should have been raised. They didn't raise knock and talk and the implications of knock and talk, and they certainly didn't raise police-created exigency. And to that extent, I think that for Dermio to represent the rule of law that anytime police knock on a window and the person doesn't respond, it justifies an entry into the vehicle out of a wellness check, would be inconsistent with Kentucky versus King and the limitations of police-created exigency, because it is in fact that knocking that's creating the exigency.
Let's come back.
Okay.
There's a report from, I think, person from own. It's unclear to me whether the police have the identity of the person who called in. I don't recall if there was.
It's anonymous.
It's an anonymous call, and it's this fellow is in the parking lot. He's kind of, I don't know. I'm going to use the word stumbling, but kind of stumbling around, and he urinates on the car. And the officer who responds knows those details, correct?
Does.
But he doesn't know who made the call.
Does not.
Citizen informant, but it's anonymous informant.
It would be
I mean,
an anonymous tipster. Yeah.
If he could act on those facts, wouldn't he have reasonable suspicion that this fellow was intoxicated?
Well, but that's why I actually go through and
he's sitting in a running car.
That's why I do that analysis in my petition about the nuances associated in somewhat of a Popple-esque form.
I like that.
The different nuances and what the officer would have to do in order to justify entry into the car. That's why I said I think this case is actually a good opportunity to discuss the fact that Coniglia versus Strom came out and said community caretaking has been used, unfortunately, over the last 50 years since 1973 as a standalone exception to the warrant requirement under the Fourth Amendment, and that's the incorrect use. Justice Alito made it very clear community caretaking was never intended to be used as that function. And now you have, subsequent to Coniglia versus Strom, you have the Taylor case, which further discusses the limitations of community caretaking. So with all due respect to the rule of law that happened as a result of Dermio, it's overbroad. And now I think the court has an opportunity to scale back and to actually now, because I correctly raised those issues and made those arguments, which were never made in Dermio, so the court never addressed it. But now the court has to address it. And since they weren't argued and addressed by the court in Dermio, Dermio is not the applicable law on those particular nuances. Coniglia versus Strom is, Taylor is, and Kentucky versus King and all those other cases that I cite you. That's where this court's going to get the instruction as to whether or not, given the facts in this case, whether it was justified. I submit it was
coming back to our second tier cert standard. Okay, if we're going to pinpoint where the circuit court, strayed from, the correct, applying the correct law, I suppose. It would have to do, and correct me if I'm wrong, but it would have to do with its declaration that Mr. Zenko's opening the door was voluntary, with its legal implication.
That's true.
And that's it. And you point that the court engaged in improper fact finding.
That certainly is my strongest argument.
Okay,
absolutely.
Could it also be characterized? Because voluntariness in these cases is really, it's kind of a mixed question of law and fact, is it not? I mean, we look at the facts. The trial court might say, "Oh, this is voluntary," and we look at the facts and they say, "Oh, no, it's not." I mean, that happens all the time in these cases.
Okay, but I think
so. In this case, though, couldn't you characterize what the circuit court did as looking at the facts as determined by the hearing officer and declare that was he voluntarily opened the door as a legal matter, and so really it becomes a question of whether that's a legal error.
Well, no, but that's not the context in how the circuit court used the voluntariness. It was a factual issue, not a legal issue. They made the determination that whatever happened was because whatever observations they made was based upon the fact that he voluntarily opened the door. That's a factual question, not a legal conclusion. It might in some instances be both, but here the circuit court used it on for the premise that factually, and that was improper reweighing. And I think that going back to our days of law school, the classic but-for test, is applicable here. But for this officer knocking and refusing to take my client's thumbs up,
right,
my client never opens the door. My client only opened the door because the officer kept knocking and kept asserting that show of authority. There's no indication in the evidence that my client, but for that knocking and persistent knocking and the officer refusing to accept his thumbs up, my client would have opened the door.
Mr. Isaac, you're into your rebuttal time. So
okay, then I'll thank you, and I'll wait to address
Ms. Jones a chance. All right. Sure. Okay, Ms. Jones, you're up. Your turn.
Good morning, panel members. May I please support? My name is Alana J. Jones. I represent the Department of Highway Safety and Motor Vehicles. And of course, as is stated earlier, it's important to remember what our standard of review is on second tier cert. And of course, was procedural due process afforded, which is not an issue in this case, and was the correct law applied? And determining whether that's the case, it has to be determined whether there was a violation of a clearly established law resulting in a miscarriage of justice. And in this case, that did not happen.
How about Ms. Jones, Mr. Isaac's position that the court did engage in improper fact finding. The appellate court did, when we're talking about the circuit court in its appellate capacity,
Yes, ma'am.
by virtue of injecting the word voluntariness and opening the door. And his position is, by that term voluntariness, that the court in fact came to the conclusion that they interpreted it on his own, that it was done in a voluntary fashion. How do you respond to that?
Well, Your Honor, my response would be looking at the context as well, looking at the context of what happened. When you look at what the hearing officer says, how Officer Barlog knocked on the window, he notes that the petitioner appeared to be very confused upon waking up. He had difficulty when he was requested to roll down his window. He had difficulty operating the controls. And as a result of those dexterity issues, he on his own opened up the door. The court was not pulling out of the sky voluntariness. He's looking at the fact that this individual, while confused, he's in a state where he's having difficulty rolling down the window, which he's willing to do. He's now on his own or voluntarily opening up the door. This is absolutely susceptible to different interpretations. And this is a reasonable interpretation that he voluntarily opened up the door given the context of what is happening. So no, the court is not reweighing evidence and pulling out of the clear blue, oh, he voluntarily opened up his door. No, he's looking at the context of this gentleman trying to respond in a confused state, being unable to operate the window controls, and then voluntarily or on his own opening up the door to speak to this officer. So no, this isn't a reweighing. This is merely, okay, sure, were different words used? Yes, but when you look at the context, it's the same concept and it's consistent with what the hearing officer said.
Okay, and then let's go back to the facts in this case.
Yes, ma'am.
You agree with Mr. Isaac that the officer's testimony that he was there to conduct a wellness check. We all agree. This is let's just call it an undisputed fact. You agree with that, Ms. Jones?
Sure, he stated that
Okay.
he had a medical concern for
Okay.
the petitioner.
So he comes up to the car, and as Judge Northcutt indicated, the car was running, but it was parked. It was parked, and he saw what appears to be an individual, either asleep or slumped over. And so when he knocks, yes, the person wakes up and then gives that surfer sign.
Mhm.
Okay.
Yes, ma'am.
So the surfer sign, okay, let's just assume that maybe the officer did not know. I mean, I didn't realize the surfer sign that I'm A-okay. I just thought, hey, man, I'm cool or whatever, but I'm not A-okay. But then
You're not much of a surfer, are you, Judge?
I'm sorry, Judge Northcutt. I must have missed that. But anyway, so the next step, Ms. Jones, and when he does it again, then this time he gets a thumbs up. So the
Okay.
thumbs up, in a way, I agree with Mr. Isaac. There's no question, thumbs up, like I'm A-okay. Why at that point, once the gentleman said, I'm A-okay, why doesn't it stop at this point in time?
Okay.
Because then he persisted. And when he persisted, that's later on the issue of dexterity, the issue of on his own and all that. But don't we have a clear line at that point, once he gets a thumbs up, that that's it? He's A-okay. Granted, the car is running. Granted, he's lawfully parked, but he gets a thumbs up.
Well, Your Honor, I would respectfully disagree with opposing counsel's view that the thumbs up sign in that instance necessarily meant I'm A-okay. The thumbs up sign can mean anything in any given context. When you look at the facts in this case, after being requested to roll down the window, that's when he puts up the thumbs up sign. Your Honor, that could mean, okay, I'll roll down my window, but he doesn't comply. And this is within the context of him still being confused, still being out of it, and the officer still having a concern for his welfare. So the thumbs up sign in that instance does not necessarily mean I'm A-okay, leave me alone. I would posit that can have any number of meanings given the situation. It could mean hello. It can mean, okay, I'll roll down my window. It could mean I'll be okay, I'm okay. But even him giving up the thumbs up sign in isolation doesn't necessarily end the welfare check if his concerns are not allayed or dispelled. If he still sees that this person is confused, if he still sees that this person is out of it, it doesn't dispel his concern. There have been instances where people have said overtly, I'm okay, and instances where objectively they were not okay. So the person in that instance didn't stop proceeding to help them, they still proceeded to help the individual. So those signs in and of themselves do not indicate that the community caretaking function stopped at that point. Furthermore, it should be noted, Your Honor, or for this panel, that community caretaking based on DeShong can be based on a concern that the person is ill, the person is tired, or the person is impaired. So it could be any number of reasons why a community caretaking function is conducted. And this point is made by counsel and has been discussed in this panel that, oh, he stated that he had a concern for he had a medical concern. That's why he was doing the welfare check. However, the case law indicates that there doesn't have to be an overt statement that there was a medical concern. As a matter of fact, an officer can state that they weren't concerned about their welfare and it still be justified as a wellness check. And that's found in Tripp versus State. That's 251 Southern 3rd, 982 in the first DCA. And I didn't include that in my response, but I thought it was important to address at this point. It's an objective test that's made when you're looking at these situations. You're not limited to, oh, I said it's medical, so therefore I have to hold on to that. No, it's an objective test. Was there a reasonable basis for the reasonable officer, seeing the circumstances that were happening at the time, was there a basis to conduct a welfare check? And in this case, there certainly was. And those signs that were given did not dispel the officer's concerns. He still appeared to be out of it. So the correct case was applied. Dermio was absolutely appropriate. As a matter of fact, the facts are substantially similar to the ones in this case, as the court, I'm sure, knows. And it's also important to note with regard to Katie versus Dombrowski. The statement has been made, Katie versus Dombrowski states that you can't have any, basically the statement's being made, you can't have any suspicion of impairment, or it has to be totally divorced of suspicion of impairment. That's what Katie Dombrowski says when you have a wellness check. But that's not what that case says. What the case isn't stating, in Katie versus Dombrowski, it makes the statement that community caretaking functions are totally divorced from the detection, investigation, or acquisition of evidence. What the court is saying in Katie, they are making a distinction between what's required for a wellness check, a stop for a wellness check, versus what's required for a stop if there's a suspicion of criminal activity. That case does not state that you can't have a suspicion of impairment. There's nowhere it states that in the case. It's merely saying, hey, if you're conducting community caretaking, you don't have to have reasonable suspicion to stop someone. That's the context of that statement. But again, DeShong states that if you want to check you can check a person if you suspect that they're ill, tired, or impaired. And that's what was done in this case. And of course, Tripp again says you don't even have to state that you're conducting a medical check or a wellness check. If the objective facts give rise to a basis for a wellness check, you have a proper stop. Now, with regard to the Caniglia case, which was mentioned by opposing counsel, that case does not stand for the proposition that community caretaking has been misapplied as to the facts in this case. In Caniglia, you had a situation where an individual was consented to a wellness check because he was allegedly suicidal. And while he left his home, the officers went in and took his weapons. And they used community caretaking as a basis to enter the home. And the court made the distinction, hey, this is not a freestanding doctrine to be applied in any setting. And the court goes on to state that this community caretaking doctrine is not to be applied to the home where you have to have a warrant. It wasn't saying that it wasn't applicable to our situation. This situation, it's absolutely appropriate. So Caniglia really doesn't even speak to the issues in this case. Similarly, in Taylor, Taylor, you do have the stop of a person who is sleeping in his car with a knife in his lap. But in Taylor, there was no effort to ascertain whether the person was well. There was no effort to knock on the window. As a matter of fact, there didn't seem to be any concern for the person's well-being. There was no attempt to rouse the person. They just opened the door, went in, got the knife. There's a K9 circling the car. He smells drugs. They go in and search and they find drugs or and paraphernalia, and then they go forward from there. Those aren't even the facts of this case. So Dermio is absolutely the appropriate case to be applied. With regard to the arguments made by counsel concerning why Dermio shouldn't be applied, because these arguments, the police created exigency argument wasn't raised in Dermio, and the knock and talk doctrine wasn't applied. That's beyond the scope of this court's review. First of all, these doctrines, or the argument of these doctrines, don't change the basic issue in Dermio, which is the same issue in this case. The issue in Dermio was there an unreasonable search and seizure which violated the person's Fourth Amendment rights? And that was exactly the issue. That was the subject of the motion that was at issue on appeal in Dermio. Likewise, counsel is making the same argument. He's using different doctrines to come to that argument, but it's the same argument. Is there an illegal search and seizure? And was there a violation of the Fourth Amendment constitutional rights? Furthermore, it's beyond the scope. What the court did below, the circuit court, they determined, based on the facts, that there was competent substantial evidence that the petitioner opened his door voluntarily or on his own. That was a finding made by the court. The court found there was competent substantial evidence for that. As a result, we don't have a discussion at this point concerning factually whether there was a police-created exigency. The court decided that issue when they found that there was competent substantial evidence to support the fact that the petitioner opened the door on his own or opened it voluntarily.
I think, Ms. Jones, as I understand Mr. Isaac's argument, is at the point, in fact, when he opened the door, as I hear Mr. Isaac saying that was well after the officer was given a signal that Mr. Zenko was okay, that by virtue of him being persistent a third time to still pursue to have him open the door, that at that point that crossed the line, that became intrusive, that became, so all the case law, and not to use, the case law as a vehicle, to basically, without a warrant. And so I guess the question for us to determine is to look at the facts as presented, to look at it, the sequence, not to jump to the fact, oh, he opened the door voluntarily.
Absolutely.
At the beginning, okay, so you had one knock and then he gets a surfer sign. He gets another knock, and this is where, and then it's interesting, is it your position that when the officer was telling him to roll down the window, that the thumbs up was done in response to that request, as opposed to the thumbs up saying, I am A-okay?
That it was after the knocking on that window, the second time, you get the thumbs up sign. So what does that mean? Okay, I'll open up the window. Okay, it could mean anything, Your Honor. And that's why the fact finder at the administrative level reached the conclusion that this was an appropriate interaction with the officer because his concerns were not allayed.
Well, let me ask you this, Ms. Jones. Let's just assume the following facts. Knock number one, he gets something that's not quite right. After knock number two, and if the defendant would have said, I am A-okay, at that point, would the officer be justified in leaving? Or under your argument that because it's objective, he hears I'm A-okay, that he still has to pursue to find out?
I'm sorry, Your Honor.
No. I'm just trying to find out, where do we go? And is there a line to be drawn until such time? When does it become objectively, even if you have a defendant saying, I am A-okay? Does that justify him keeping on?
Well, based on the context of this case, Your Honor, it does appear that it was justified for him to continue to knock because he was still confused. There's no indication that that confusion of the driver had somehow dissipated. The officer didn't indicate in his report that, oh, now he was clear-headed, he was coherent, he was able to speak.
So like if you took a more extreme hypothetical, if he's sitting there with blood running down his face, but tells the officer, I'm okay. At that point, you're saying the officer doesn't have to take the person's word for that in terms of.
Of course, and that, of course, as you said, that's an extreme.
But this is a more nuanced
Absolutely.
situation, but the principle would still apply.
The same principle applies. Exactly, Your Honor. Just because someone says they're okay, and again, it's debatable whether that thumbs up meant I'm okay. I mean, that was something for the fact finder to find at the administrative level. The circuit court found there was competent substantial evidence for that finding of the fact finder. And certainly at this point, we're not in a position to debate that point. The question, the issue is the officer's concerns were not allayed, which justified him going forward, which is in keeping with Dermio. So the officer, and again, we have to consider the whole context. As Your Honor Northcutt stated earlier, this was a gentleman who was reported to have issues going to his car. He had trouble struggling to get to his car. He urinated on the car. He's in a parking lot, car running 7:30 in the evening in a bank parking lot in a tow-away zone. I mean, all of these factors are not favorable factors. And these are things that are lending to the concern that this officer has. And there's nothing in the evidence that indicates that that concern was allayed by the actions of the defendant or anything that he said, and certainly not by the, at best, equivocal signs that he's giving in response to the officer. It could be argued that those responses were non-responsive responses. So the officer looking at this situation was justified in going forward to determine what is wrong with this individual, what's happening with this individual. And then, of course, we get to the point where the door opens and then eventually the indicia of impairment are observed. And it's important to note that this doesn't turn into an investigation at the point of the knocking, at the point, even when the individual opens up the door, even when he on his own voluntarily gets out of the car. Once the officer observes the indicia of impairment and sees the bloodshot eyes, the flushed face, the swaying, and so on and so forth, the point where it turns into an investigation is when the officer finally says to him, I would like you to submit to field sobriety exercises. That's when it becomes an investigation, a DUI investigation at that point, not at the point of what has been termed as persistent knocking. The knocking continued because the concerns weren't allayed.
And Ms. Jones, you are at the end of your time.
Thank you, panel members, for your time.
Thank you very much. Okay, Mr. Isaac to rebut.
I can't.
And Mr. Isaac, I know you're itching to respond because I could see based on your expression, but help me out with one thing.
Okay.
How do you respond to Ms. Jones' statement that when the second knock, when the officer was asking to roll down the window, he gets a thumbs up, and that could be interpreted by the fact finder to be in response to that request, that yes, thumbs up, trying to open the window, not able to open the window.
Well, her interpretation was not any factual findings that were made by the hearing officer. So she's now asking you folks to make factual findings that the hearing officer didn't make, which is something you can't do either. You can make it, you can certainly draw natural inferences, what is a reasonable inference, but what she's asking you to do is impermissible as well. And a thumbs up is universal. I'm okay. So I'm not asking you to do anything other than to.
Well, I don't know, Mr. Isaac. It could be, hey, I hear you. I'm working on it. You know, don't rush me. I mean, it can be, I'm okay. Can be, hey, I hear you. I heard you.
Oh, well, I think that the natural inference or the logical inference is I'm okay. I disagree with Ms. Jones' interpretation. I don't think most people think that that's what it is. And I'm going to ask your honors, when you first read this and you saw a thumbs up, what was your first inclination? I'm okay. I think that's the way people interpret it. So, but I think that what Ms. Jones is doing,
representation of being okay become one, the veracity of the investigation and binding on the police officer at the scene in terms of doing the community caretaker.
I'm sorry.
Why does that become dispositive? I mean, most of us have seen people in DUI cases before, or I'm fine, I'm telling you there's no problem. They go staggering all over the line. Why is it that because he puts up in whatever form, that becomes dispositive to the police officer and causes the investigation or the community care check to stop? Because the language of the Taylor case talks about the welfare of not just your client, but the welfare of the citizenry at large. So my concern is, why can't the officer keep going, even if he puts a thumbs up 3 times to verify?
He can. However, that's why I go through that discussion, the different nuances. What the officer could have done at that point is look inside the car and whatever he can see in plain view. Does he see open containers? Does he see drugs? Does he see chemical substances?
Okay.
Does he see injury? Are there liquids? Is there blood? Is there trauma? Is there a gun? Is there a knife? Anything that's in plain view, he can objectively look at the context and the circumstances to see what's happening. But that's not what he did here. All he did, instead of walking around the car, instead of seeing what he could see, all he did was continually knock, knock, knock. And after my client gave a thumbs up, he refused to take that acknowledgement. And one of the cases that I cite to, the Brown case.
Well, does he have to take no for an answer?
I'm sorry?
Does the police officer have to take no for an answer under these circumstances?
If the car
Which is effective, I'm okay.
If the car is lawfully parked, then yes, because
yes, but this car has the engine running, and that means the driver is in the actual physical control of the car, which is an element, depending on investigation, which may lead to it. So he has a dangerous instrumentality there, and he wants to make sure this person is okay. And it sounds like what you're arguing is the minute that person says, hey, thumbs up, the wellness check stops. I'm not sure that's what the law says. That's my problem with the analysis so far. And Taylor talks about finding drugs in the car, that they totally no problem. The guy was sober and the car was not on. I understand the argument, but I'm not sure Taylor gets us there by itself. And what you're telling me, I look at Katie versus Dombrowski. Katie versus Dombrowski, the car was in a police impound lot, right?
Yes, sir.
And the other case is going into the sacred Holy of Holies, the house. So I'm trying to make sure I navigate through all these cases to determine whether or not the standard of review that the trial court departed from the law in a material manner that creates harm. I'm not sure I'm there yet. That's why I want you to tie it all together for me.
Well, before you take too much time, Mr. Isaac, I'll point out that you and Judge Castanueva have used up your time. So I'll let you.
Okay, I'm
wrap it
sorry.
up.
I'm sorry. Then I'll withdraw the question and you don't have to worry about it.
I would
I'll
very
read the
much
brief
like
again.
I would very
It's
much.
up to the chief.
I'll
I
let
have
you
permission
finish
to
up your
answer?
thought, but yeah, but go right ahead.
Thank you, Judge. So Judge Casanueva, just because my client is sleeping in a lawfully parked car, what is he doing wrong? Are we going to suggest that simply because
This
somebody's,
didn't start out as a wrong. This started out as an investigation to make sure he was well.
I understand that, but once my client gives a thumbs up, he's sitting in a lawfully parked car in Florida. It's not unreasonable that people would have the car on so that they have air conditioning. Are we going to suggest that simply because law enforcement finds somebody in a car that's lawfully parked with the engine on, that justifies continued knocking by police to say, I want to check on you, even though you gave me a thumbs up. I don't want to accept your declaration that you're okay through your thumbs up. So I'm going to continue to knock and knock and knock and give a show of authority to force you to come to give in to my shows of authority so that I can verify and I can be secure in my notion that you're okay, even though objectively I can see into the car and I don't see anything wrong. I don't see illegal substance. I don't see open containers. I don't see any injury to you. I don't see dangerous instruments to you. Objectively, I don't see anything other than a person sitting in the car.
Okay,
that's running.
This point, I'm going to call the game. So,
okay, thank you, Judge.
Thank you both. Very, very well argued case.
Very,
And
very well argued.
in order to leave the virtual courtroom, there is a button on your Zoom screen. It's called Leave. And if you click that, you will leave and go off into the ether.
Thank you.
Thank you,
Thank you
panel
very much.
members.
Bye-bye.
Okay, the next case is DeAndrea versus Arnul, I guess is how you pronounce it. Okay, doke. Counsel, you're up.
Good morning, Your Honor. I'd like to reserve 5 minutes of my time for rebuttal. My name is Andrew Fine, and I represent the appellant, Peter DeAndrea, as personal representative of the estate of Ann Sims. This case presents an issue to this court of which statute of limitations should apply to the appellant's action to enforce 2 promissory notes. And specifically, I would like this court to approach this case by specifying what law applies to what issues in the case. Because in preparing our brief and in our argument, it seems clear to me that where the appellate courts have gone astray on these types of cases are instances where the parties weren't careful about arguing which law applies to which issues. So because we are here in Florida, we, of course, must start with Florida law. And Florida law very clearly says that a cause of action on a demand promissory note does not accrue until demand is made. That's 95.0311. There's no dispute that in this case, the first written demand wasn't made until 2019, and therefore our suit was filed well within the statute of limitations, which is 5 years. Florida statutes of limitations are procedural in nature, and Florida will always apply its own statute of limitations to its own cases. That has been the law for many years. That's how the law was stated in Calhoun versus Greyhound, which was a Florida Supreme Court case in 1972, where the court said that statute of limitations are traditionally procedural and the law of the forum will apply.
But Mr. Fine, if I may, then after that, as Apolli, pointed out, didn't the Supreme Court kind of ventured away and and Lumberman's, didn't they say, and I quote, recognize a trend away from calling statute of limitations procedural and provided that the issue of which statute of limitation applies should be determined like any other choice of law issue. And if you follow Lumberman, and Lumberman, if you look at the facts of that case, they basically concluded that the Massachusetts statute of limitation applied because, and then they go through the language that pursuant to Florida's borrowing statutes, you need to look at Massachusetts law in order to determine the applicable limitation period. And so, and this language and all of this, it boils down to the legal term of, okay, lex loci contractus. And if you follow that, doesn't that go contrary to your argument that the trial court appropriately came to the conclusion that New Jersey law applied because that's where this issue, the contract was entered, and that was the place that ought to be, the statute of limitation ought to be governed. Give me an opportunity to respond to that, Mr. Fine.
Thank you, Your Honor. No, Your Honor, I don't believe that the trial court relied on that correctly, and I don't believe that's what Lumberman's stands for. So if you read Lumberman's was a September 1988 case. It was resolving conflict with Storiano, and Lumberman's was specifically limited to contracts of auto insurance. And I want to quote to you because it's very important, because not following this specific language of the opinions is where the court, I believe, went astray below, and other appellate courts have gone astray. The court in Lumberman said, accordingly, the lex loci contractus rule determines the choice of law for interpretation of provisions of uninsured motorist clauses in automobile insurance policies, just as it applies to other issues of automobile insurance. Now, they were resolving conflict with Storiano that the Supreme Court had decided just a few months prior to that. And if you look at Storiano, which is 523 Southern 2nd 1126, the court there specifically limited that case to automobile insurance contracts. And it says that at the bottom of page 11, on page 1128 of the opinion, it says, we answer the certified question in the affirmative, limiting this answer to contracts for automobile insurance, and approve the decision of the district court. And in fact, the court was so concerned about limiting it, they said it again at the end of the opinion on page 1130. For these reasons, we answer the certified question in the affirmative, limiting that answer to situations involving automobile insurance policies. So,
how about Mr. Fine then? If you jump up to Lanui versus Risk, that dealt with a promissory note, and that case, wasn't there a suit to enforce a promissory note? And that's when the third DCA basically said that for causes of action arising in contract, which is our case here, that Florida adheres to the doctrine of lex, whether it's called loci or loci contractus. So that case dealt with a promissory note.
it did, Your Honor, but I would respectfully say that that case was, one, wrongly decided, two, is not binding on this court. And you can see how it was wrongly decided because they cite to Lumberman's as the support for that. But Lumberman's was not at all a promissory note case. So to cite to Lumberman's in a promissory note case is incorrect, and more importantly, ignored other precedent of the Florida Supreme Court, the Shapps case, which we'll talk about in a second, and even the Brown case from 1920, which was cited in Strauss v. Sillen, which both say that in a promissory note case where you have a note that's executed outside the state of Florida, but a suit brought in the state of Florida, that Florida law applies. The Florida statute of limitation applies. So again, this is why it's very important to specify which law are we talking about? Are we talking about substantive law, or are we talking about procedural law? Because even opposing counsel agrees that some Florida law applies here. They want to apply the Florida law of lex loci contractus, all right? But it simply doesn't apply here because statute of limitations are procedural in nature. And that was exactly this court's holding in Strauss v. Sillen, which is exactly on point, decided in 1981 and remains good law. There
But
was
how about, and I appreciate Mr. Fine, but then if Florida law, but doesn't Florida, if you look at Florida law, don't we have the Florida the borrowing statute, 9510, 95.10, that basically says that when a cause of action arose in another state, which it happened here, it says that it's okay, let me quote it exactly. And its laws forbids the maintenance of the action because of the lapse of time. No action shall be maintained in this state.
But I have two responses to that. First of all, the law of Florida, and that comes from our own statute of limitations, 95.031, says that the cause of action accrues upon demand. So the cause of action didn't accrue in New Jersey under Florida law, it accrued in Florida under Florida law. But more importantly, when you go and look to New Jersey law sends this right back to Florida under the New Jersey statute that we cited in our brief, which is 22 New Jersey statutes 2A 14-26.2. That specifically says that if the statute of limitations of a different jurisdiction applies, then the statute of limitations of New Jersey doesn't apply. And very clearly, the statute of limitations of Florida applies here because you're using the borrowing statute to get to New Jersey, and the borrowing statute is part of our statute of limitations. So New Jersey law is sending it right back. Now, the trial court, in entering his order, distinguished that statute by simply saying, well, that statute wasn't in effect in New Jersey until the late 90s, and these causes of action had already expired by then. So the court dismissed that statute and didn't apply it for that reason. But that wasn't the correct analysis. And the trial court didn't have the benefit of really having that point argued below because it wasn't argued at the hearing below. But if you looked back at New Jersey case law prior to that statute, in the case of Jackie versus Benjamin, which was a 1910 case, New Jersey law said statutes of limitations are remedial and therefore they are procedural. And therefore, the law of the forum applies. And in fact, in Jackie versus Benjamin, it was similar facts to this case. There was a promissory note signed in Connecticut, sued upon in New Jersey, and the court said, we're going to apply our New Jersey statute here. It didn't apply Connecticut statute, it applied the New Jersey statute. Similarly, that is exactly what this court did in Strauss. There was a note signed in Georgia, due and payable in Georgia, sued upon in Florida, and this court properly said that the statute of limitations is procedural and that Florida law, the forum statute of limitations, would apply. And none of that has been changed by any subsequent law. The cases that Your Honor alludes to that talk about getting away from lex loci and are also say that we should look to the significant relationships test when deciding where a cause of action has accrued. But that really isn't the law yet in Florida, although there may be a trend there. That isn't the law. The Supreme Court in Shapps accurately stated the law when they did their analysis there in footnote 3 in that case, which said that under lex loci contractus, the law of the jurisdiction where the contract was executed governs substantive issues regarding the contract, substantive issues. All right. But then they went on to say that Florida conflicts of laws jurisprudence directs that procedural issues are controlled by the law of the forum, which is Florida in this case. And that case, Shapps, was decided in 2002, long after Lumberman's. So if Lumberman's stands for the proposition that statute of limitations is subject to lex loci, that this footnote contradicts it. But Lumberman's doesn't, but the reason this footnote doesn't contradict it is because Lumberman's doesn't stand for that. Lumberman's was just limited to auto contracts, which provide a odd intersection of tort law and contract law.
So, Mr. Fine, if we follow your approach, that means we'll have to certify conflict then with Lanui versus Risk.
Well, yes, perhaps, Your Honors. I don't think you have to, because I think Lanui was also distinguishable in that in Lanui, there were agreements that had choice of law provisions in them that were ambiguously written to reference Ontario law and the state of Miami law. And the court said both of those apply, and they're in contrast. And then in one short paragraph said, well, we're going to use as kind of the tiebreaker here, lex loci, and lex loci says the law where it was signed. I think that case can be distinguished because there were bilateral contracts involved there. There was a security agreement signed by both parties. And I think that's an important distinction here, because here we have a promissory note that is only signed by one party. It's only signed by the maker, and it's a negotiable instrument. And it's certainly a special kind of contract. And so to apply all of the law that applies to lex loci simply to promissory notes is a little bit of trying to fit a square peg into a round hole. It just doesn't work correctly. But yes, this court is not bound to follow Lanui from the 3rd District. And if the court wanted to certify conflict, it could certify conflict. But
Mr. Fine, you are at your rebuttal time, so proceed as you wish.
Okay, thank you, Your Honors. So I think the Shapps case makes it very clear that the Strauss case is still good law in the 2nd District, which, regardless of what you think of the Lanui case from the 3rd District, this panel has to follow good law in Strauss. It's binding opinion from the 2nd District. It hasn't been overruled, and were this panel not to follow it, I believe it would create intra-district conflict and lead to a grounds for an en banc rehearing. I'll reserve the rest of my time. Thank you, Your Honors.
I was going to do this. Okay, Ms. Jamo, you're up.
Good morning, Your Honors. Can you hear me okay? Perfect. Thank you very much. May it please the court. My name is Caitlin Jamo, and I represent Frederick R. Newell, who respectfully requests that this court affirm the lower court's grant of summary judgment. I want to start by saying our primary position here today, looking at this globally, is that these 2 or 3 different standards or processes for looking at what law applies can all work together. While our position is that lex loci contractus is the appropriate standard to be applied to these facts, our position primarily is that none of the cases that are relied upon in either of the parties' briefs or here today in oral argument were improperly decided or can't work together in some fashion. Now, there certainly is a gray area in terms of whether there's overlap between lex loci contractus, significant relationship test, or even the current extent of the existence of the substance versus procedural analysis. But based upon all of the cases here today, and frankly, I'll even rely heavily upon the Shapps footnote 3 of the Shapps decision, we can see that all of these standards, particularly the significant relationships test and the lex loci contractus test, can all work in tandem. We do think here today that the court, first and foremost, appropriately relied upon lex loci contractus in determining that New Jersey law applied. Now, I want to take a second to clarify and highlight that, yes, this is a statute of limitations issue, because statute of limitations is the vehicle by which the trial court rightly found that the 1984 and the 1986 promissory notes were barred by the statute of limitations. But there's two questions, and really the dispositive issue between New Jersey and Florida law is that of accrual. Because under Florida law, as stated by appellant, the cause of action for a breach of note did not accrue until 2019, more than 30 years later, when there was a demand. Whereas in New Jersey, it accrued upon the execution and delivery of the notes at issue. So even if we're looking at this as a substantive versus a procedural issue, we're looking at a major part of what the rights and the obligations of the parties are in terms of whether or not Mr. and Mrs. Sims, the original individuals who loaned, were required to do anything in order to enforce their rights and their obligations under the notes here in order to have a cause of action and preserve a cause of action for breach of note. So because we're looking at this, then the doctrine of lex loci contractus becomes appropriately applied. That doctrine, as explained in Lanui, in the lumberman's case, in the cases that we already discussed here today, stands for the proposition that when you're looking at and interpreting a contract provision or the rights and the obligations of the parties, the law of the state where the contract was entered into is the law that should be applied. Here, because it's New Jersey, at the time that the note was executed and then delivered to Mr. and Mrs. Sims, at that point, the cause of action accrued in 1984 and 1986, and by 1992, under New Jersey statute of limitations, then at that point, the cause of action and ability to enforce these notes no longer existed. Lex loci contractus makes sense, and the policy as articulated in the Suriano decision is that parties should not be able to move in order to change what law governs their relationships, their rights, their obligations, and what the interpretation of the provisions or what their obligations are. Now, appellant tries to distinguish lumbermen's and narrow lumbermen specifically to the context of insurance, which I agree that the language cited does specifically refer to insurance policies. But as Your Honor pointed out, Lanui stands for the proposition, even if you have distinguishing facts in there, that lex loci contractus should be applied in the context of a promissory note. I'll also rely upon footnote 3 in the Shapps decision, where the court did not specify that lex loci contractus should be applied only to insurance contracts, but used more general language that lex loci contractus applies to contracts.
I pulled the footnote because I wanted just to reread it. And the footnote in Shapps, which Mr. Fine wants us to, saying that it governs our position, it says under Florida conflicts of law rules, the doctrine of lex loci contractus directs that in the absence of a contractual provision specifying governing law, a contract other than one for performance of services is governed by the law of the state in which the contract is made. And in our case, we didn't have a contractual provision specifying the governing law. So the Shapps case really doesn't contradict what Lanui says. It basically supports, or at least they both are consistent. Let me put it this way.
Absolutely.
Because I was troubled with what Mr. Fine was suggesting, that perhaps if we come to a different conclusion as Lanui, that somehow we are running in conflict with Shapps. But in looking at the footnote, and the Shapps case dealt with an insurance issue, did it not? Okay.
Yes, Your Honor.
I'm sorry. Go ahead, Mijum.
No, Your Honor. And I absolutely agree. Footnote 3 in Shapps is of particular importance. And we agree Shapps, it certainly is the law, and we have no challenge to the law that was articulated in Shapps, and don't even try to narrow it. In fact, footnote 3 goes on to also cite the Strauss decision, which is relied upon by appellant in this procedural versus substantive analysis. Now, subsequent cases such as the Bates decision, Bates versus Cook from 1987, starts to talk in terms of a trend away from procedural versus substantive, but I'll acknowledge that there are more recent decisions where you still see substantive versus procedural analysis. And that's where the gray area I articulated at the front end comes into play, because there is a little bit of these three standards floating out into the ether and figuring out when they should or should not apply. But footnote 3 of Schaps is of particular importance because it shows that lex loci contractus, and whether it's a significant relationship test or specifically the substantive versus procedural test articulated in Strauss, that they are both the law, they are not contradictory. And our position remains that they are both the law and they are not contradictory. But rather, when a court is interpreting the terms of a contract, or a court is determining the rights and the obligations of a party in a contract situation, that lex loci contractus is the appropriate standard to articulate. And that applies specifically to the Lanui decision, to notes, as we can see in the Lanui decision. This court does not have to overrule or certify conflict with any other decision from any sister court or of the Florida Supreme Court in ruling in favor of appellee here today. All of these standards can apply and can work together. One thing I want to highlight as well, just because it was raised in oral argument, is to clarify from the New Jersey law standpoint the interplay between what almost appears to be two competing borrowing statutes, where New Jersey law says that you can look to Florida law, and Florida law says where the cause of action arose, you should look to New Jersey law, at least in this specific instance, if the court determines it arose under New Jersey law. And one thing I first want to highlight is that under the cited section, which is 2A 14-26.2, it wasn't adopted until after the statute of limitations had already run in New Jersey. And as we cited in our answer brief, Sarasota Coolidge versus Rotondi, a New Jersey Superior Court decision, that it's inappropriate to then rely upon that specific section, which was adopted after the demand notes had already been created. So in terms of what is the appropriate law is looking at 12A 3-122, which was in effect in 1984 and in 1986, and frankly, all the way through the extinguishing of these claims at the time, which created the accrual was as of the date that the notes were entered into in 1984 and 1986, and that they subsequently extinguished 6 years later in 1990 and 1992 when the 6 years period of time had lapsed. Now, Your Honor, while we do maintain that lex loci is the appropriate standard, and full stop, that could be the end of the court's analysis. To the extent that the court does want to engage in a significant relationship test or even under the substantive procedural test, we would point to the fact that the only relationship between the parties here in Florida is that Mr. and Mrs. Sims, at the time the notes were executed, resided in Florida. But the drafting of the notes, the execution of the notes, the delivery of the notes, the conversation surrounding the notes all occurred within New Jersey. So if the court is inclined to engage in a significant relationships test, our position would be it would still be appropriate to apply New Jersey law, just because the significant relationship at the time that these notes were entered into by between all of the parties, Mr. and Mrs. Sims and Mr. and Mr. Arnul, occurred within New Jersey, and we would rely upon our record sites and our affidavit in opposition or in support of the motion to dismiss, which was incorporated into the motion for summary judgment at 247 to 248. So, Your Honors, with this, I'm happy to go through a further analysis in terms of the significant relationship test. But really, at the end of the day, because this is a promissory note and because of the language included in Lanui, as well as, frankly, even within the Schaps decision, it's appropriate to apply the Lex Loci Contractus, which is clearly that of New Jersey. And with that, Your Honor, I don't have any additional substance that I would bring forth. We've included a number of other arguments within our answer brief, but just based upon the arguments raised in oral argument for appellant today, that seems appropriate. But I'm happy to answer any additional questions.
I have no questions.
Thank you
Okay.
very much.
Thank you, Ms. Jamo. Mr. Fine, you're up for rebuttal.
Thank you, Your Honor. So I want to again address Judge Kuzam's question about footnote 3 in Schaps, because I submit it's not appropriate to simply read that first sentence of footnote 3 and conclude that the New Jersey statute of limitations should apply, because, and it's important to look at what was going on in Schaps. All right, so in Schaps, there was an insurance contract that was utilizing Lex Loci and applying New York law. It was applying New York substantive law, but the court nevertheless ruled that the Florida burden of proof would apply, not the New York burden of proof, and that burden of proof would apply because burden of proof is procedural. So that footnote, and that's why in the footnote, while they state the general law initially, they then break out substantive versus procedural, which again is what the court needs to focus on. All right, the substantive issues here, even if this court finds that this was a New Jersey contract, the substantive law would be New Jersey, usury, etc. But they go on to say in the footnote 3, Florida conflicts of law jurisprudence directs that procedural issues are controlled by the law of the forum, and statute of limitations is clearly procedural, as said by this court in Hout versus New River in 2005, which I would point out, Judge Casanueva was on the panel.
And if I may, Mr. Fine, because I know you're only on rebuttal, I want you to give it the opportunity to respond to Ms. Jamo's about the significant relationship that if we go there, that you said even applying that still New Jersey would apply. I want you to have the opportunity before you're cut off to address that.
Sure, Your Honor, thank you. So clearly the significant relationship test would be applied here and in all directions points to Florida. This loan was made by Florida residents, all right? There was no place of payment specified. So under Florida law, payment was due where the creditor resides. That's Florida. We now have a Florida estate suing to enforce that obligation against a Florida resident. So the only thing that happened in New Jersey was that these notes were signed in New Jersey. Everything else about this case, the lenders and where the payment was due, was all Florida. So we would be happy for this court to apply the significant relationship test here, because we believe that can only lead to one conclusion, which is that Florida has all the significant relationships here, save the fortuity of where the note was signed. And to rely on that fact in today's age of digital signatures and DocuSign, as opposed to looking to where the lender resides, makes it very clear that Florida has the most significant relationship here. So in ruling, I want the court to recognize that either this court's going to have to make a ruling that's in conflict with Lanui from the 3rd District, or is in conflict with Strauss v. Sillen, which is this court's own decision, exactly on point factually, cited with approval by the Supreme Court in Schaps, also cited subsequently in an additional time in Hertz versus Piccolo, and is still good law. So if this panel doesn't reverse on the grounds of Strauss, then it's going to be in conflict with Strauss. And for those reasons, we think that the court should reverse. In fact, I'll just close by quoting Strauss, which was relying on a case called Brown versus Case from 1920. And it said, Strauss submits that the trial court should have followed Brown v. Case. We agree. I make the same argument here. We submit that this court should follow the Strauss v. Sillen and reverse because the case is directly on point and binding precedent. Thank you, Your Honors.
Thank you, Mr. Fine. Thank you both very much. In order to leave our virtual courtroom, you need to click the button called Leave on your Zoom screen, and you will disappear. Thanks. Oops. Okay, the next case is United Property and Casualty Insurance Company versus Miller. All right, counsel, begin whenever you.
Good morning, Patrick Chidneys for the petitioner, United Property and Casualty Insurance Company. I'd like to reserve 5 minutes for rebuttal. So the procedural background that led to this petition is a little convoluted and idiosyncratic, but the question of law before the court is not. May the plaintiffs redact the header of an email upon which their expert relies as attorney-client privilege or work product. Now, this should seem a little odd to the court. It strikes me as odd because usually it's the other way around. Usually it's a party redacting the body of an email, and then in their privilege log, they disclose the sender, recipient, date, and time.
Mr. Chambers, do you agree that in this court anyway, the standard for getting a cert petition or having an order that is cert worthy based on the denial of discovery is that that denial has to eviscerate the party's claim or defense?
That's correct, Your Honor. And I'll
is not getting this discovery about these emails, about an email to an expert during a deposition, eviscerate your client's defense?
It does, Your Honor. And there are two forms of irreparable harm, but to understand that, you got to understand a little bit about the idiosyncratic nature of the expert's report, what happened at the deposition, and how the trial court ruled.
Is the expert going to testify at trial?
That's correct. This is their only causation expert. But
right. And do you have a causation expert?
Well, we do, Your Honor, but I'll go back. Their expert doesn't necessarily have to testify at trial, and that's important because the deposition could be used in lieu of live testimony.
And if assume what you seem to be trying to prove is that counsel emailed photos to the expert during the deposition.
That's part of it, Your Honor.
The expert's opinion.
That's part of it, Your Honor, but it's more fundamental and more important than that, because this expert, Mr. Rennie, he's never visited the property. He's never conducted any tests at the property, didn't send anyone to inspect the property.
Sounds like impeachment.
Well, it would matter certainly for impeachment, and I'll come back to that, because impeachment is also a basis for certiorari review if you can't establish on plenary appeal what that impeachment evidence was going to say. Now, I need to go to the core how important this is.
Okay, go ahead.
So,
I mean, you can tell I'm a little skeptical here.
Of course, Your Honor, and I want to try to remedy that. The opinion in this case is unusual. It's this photograph only opinion. Now, Mr. Rennie shows up at his deposition, and 10 minutes before the deposition, he sends us 15 to 20 emails. Those are not at issue. During the deposition, he sends us 4 screenshots of emails. Now, those are the emails that are at issue in this proceeding. At the beginning of the deposition, we turned right to this report, his expert report, that relies on 8 attached photographs. And the curious thing about it is the only dispute in this case involves interior damage. Now, Mr. Rennie is the only causal link to the interior damage. He's the only expert they have on this. He's the only person who's going to testify at trial. In the observation section, which is at Appendix 360, he has one sentence that says, I observed interior damage, down gradient from roof damage during the site inspection. Well, that's curious because he never inspected the property. So we asked him, what do you mean? What do you mean by the site inspection? And he says, well, I'm referring to the photographs in my report. Now, he specifically says that. So we want to clarify that. And he confirms for us that the entirety of the damages he documented are the 2 photographs attached to the report. We then went further and asked him, can you confirm those are the only photographs of interior damage you have for your opinion? And his response to that was, I need to take a minute to look. And we say, take your time. And he says, yes. Now, as I'm sure the court knows, shortly after that, the opposing counsel requested a 5-minute break. After that, Mr. Rennie comes back and says, I went back and found in my deleted box, the link to other photographs, 154 new photographs he had not previously produced. Now, we proceed to try to uncover the origin of these photographs, and he sends to us an email, a screenshot of an email at 12:02 p.m. He placed this email directly at issue as the foundation for his opinion. But the only thing missing from it is at the very top, if you look at Appendix 59, in parentheses, is work product attorney-client privilege.
I'm waiting to hear how this eviscerates your defense, Mr. Children. I mean, I understand the scenario that happened.
Yes. So the first aspect of this is that we challenged this opinion at a Daubert hearing. And at that Daubert hearing, we argued that in his initial testimony before the 5-minute break, he said that he had no idea what these pictures were. He didn't know if they were in the same room, different rooms, who took them, when they were taken. And we said that's not sufficient under Daubert. The trial court disagreed, found this methodology sufficient. Now, at trial, an expert doesn't have to lay the factual predicate for their opinion. An expert can walk into court and say what their ultimate opinion is, and it's up to the opponent to cross-examine the expert. Now, this great latitude you have to challenge an expert is the obligation of the opponent of that testimony to try to attack the discernible, factually based chain of underlying reasoning. In this case, the only underlying chain of reasoning is a set of photographs. We are entitled to know which photographs were actually part of this opinion that he disclosed months before his deposition, and which ones are not. That opinion, this causation opinion, is the core of the issue to be presented at trial. And we are entitled to question the fundamental pieces of that opinion. And without doing that, we have no defense.
And having the headers to the emails, does that how?
The header of the email will tell us if these particular photographs were received by this witness back when he formed his opinion, like he testified after the break, or whether he never saw these photographs at all when he formed his opinion in this case.
Yeah, but he's not entitled to change his opinion or modify his opinion based on further information given to him?
Well, the other side of that coin is if he's allowed to just continually change his opinion, we're entitled to see the information that he's relying on. And he produced it for us.
But having these headers to these emails is critical to that inquiry?
It is, because it would impeach his...
That eviscerates your defense?
It would eviscerate our ability to challenge his opinion disclosed in his report. And now if he's going to change his opinion months after the expert disclosure deadline, that's fine, but we're entitled to see that information he's relying on.
And how come you get a cert from this rather than correct any error that occurs on appeal from a final judgment?
Well, 2 pieces. Think about what happens on plenary appeal. If we go up on plenary appeal with this record, they're going to say you can't show that he didn't rely on those emails back when he formed his opinion in his report, and so we can't establish the error is harmful. I'm sure we're going to see that on plenary appeal. If we can't tell the jury, no, his opinion that he disclosed to us is not based on that 154 photographs, like he testified originally, it's based on the 2.
And what difference would that make to your defense?
It would certainly allow us to call into question this foundation, again, the factually based chain of underlying reasoning supporting his opinion.
Not suggesting the photos are doctored.
The photographs, the additional ones?
Right.
No, I think the email.
You're not suggesting, as far as I can tell from the briefing, that they, in terms of quality of what they're showing, differs substantially from the photographs taken by your own investigation.
No. What they've altered is what he claimed to rely on in that email. When he sent us the email with the links. But I also want to point out the second piece of what I was talking about. This, like I said, this deposition could be presented at trial. When this witness takes the stand, he places his credibility in issue. Now, another piece of simply impeaching the foundation for his opinion, which again, we need to know exactly what photographs he had so we can challenge those at trial, and trial is set to occur at the end of next month. The second piece of this is when we came back from that break, his testimony on the record was, I went back and found the link in my deleted folder. Now, if he received this email sometime other than when he said back in, it's 5 months earlier, 8 months earlier, when he formed his original opinion, that statement's not true. And if we are entitled at trial to impeach his credibility, if that statement is in fact not true, it's not true because if he received the deposition, say in the middle of the email in the middle of the deposition, he didn't go back to his deleted folder. He didn't find it in the deleted folder. He had it right in front of him. And, you know, it begs the question to me, why redact just the headers? You know, I still can't get past that. Why would you send this to us? Their expert sent it to us, said I relied on this, but you can't see when I looked at it. Now, I don't think there's much of an argument on the essential requirements of law here. That information is not privileged. It's not subject to work product. That's exactly the information you're supposed to disclose in Florida if you want to assert privilege or you want to assert work product. It's what you would ordinarily include in a privilege law. There is no case law. We saw nothing. And there was an argument in the trial court, but the response to our petition makes no argument that this information is in fact privilege or work product.
And if I may, Mr. Chinese, can I just jump in and maybe to follow the thread of Judge Northcutt? At trial, aren't you allowed to get into all of that? You could certainly impeach the witness by saying, when we took your deposition, you indicated you relied on these 2 photographs. Then we've taken a 5-minute break, and lo and behold, you now indicate that you're relying on these 150. You're still able to bring all that out for impeachment purposes to make that expert look bad or issue regarding credibility. You're not being limited by that. So which then begs the question, you're up here on cert. And on cert, there has to be a clear departure that any type of this type of information, that is really critical. If you're going to be allowed to proceed with your impeachment, how can that still be cert worthy in this case?
Yes, I think the key there is that we will not be able to impeach it. The point is, after the deposition break, he came back and said, this refreshes my recollection. I did review these 154 photographs. And then he, by his own volition, sent us this email as to prove that fact, but he had omitted the header. Now, at trial, I presume, if he testifies live, consistent with this deposition, or they admit the deposition, either way, he tried to come back and say, actually, no, yes, I did review those. And here's the proof. He emailed it at 12:02. So we will not be able to impeach him because we won't be able to say, no, you didn't. That thing you're giving us as proof that you relied on these photographs, you did not have that when you rendered your opinion. You got that in the middle of your deposition. We won't be able to show you that on plenary appeal. And as I said earlier, I'm sure the argument will be the jury issued a credibility determination, and we'll be missing a critical piece of impeachment that under the rules of procedure and the rules of evidence, we are absolutely entitled to. That is.
But Mr. Childress, right off the bat in your brief, you cite Dempsey and Stewart, you know, for the proposition, hey, you need to be able to get this stuff because it's critical to be able to cross-examine the experts on the basis for their opinion, correct?
That's correct.
Both of those decisions were on appeal from a final judgment. So I'm still having trouble, since this goes to impeachment of an expert as opposed to the core of your defense. I'm still having trouble how this gets to be a cert.
Sure. The core of the defense, again, you have to understand that this is the only evidence they have of causation and damage. It's this.
The core of your defense is that it's not that the damage. I'm restating the core of your defense is the core of your defense is not that the other side only has one kind of evidence, right? The core of your defense is that the truth is otherwise.
No, they do have one type of evidence. They have just photographs.
How does that become the core of your defense? The core of your defense has to be there's no causation. That's the defense.
Right, but they're building their causal bridge using only photographs. And so the key, the crux of our defense at trial. Now, I think that in many circumstances, I think the trial court's Daubert ruling was probably about as tenuous as it can get. This witness, as to the photographs in the report, had no idea who took them, couldn't say if they're in different rooms, didn't know when they were taken, didn't know anything about them. The trial court let that slide, and I recognize that's not up right now. But that's the world we're living in at trial. We're living in a world where this witness is going to rely only on photographs attached to the report. And by relying only on photographs, that is the only thing we can attack. We only have the ability to attack the discernible, factually based chain of underlying reasoning. In this case, that is nothing more than photographs. And so which photographs they're talking about, that's the critical that's the only way we can defend the case. So does it go to the core of our case? It goes to the core of their case. It's our only ability to defend against it. Nobody else is going to get up and say, this damage was caused from the roof, this damage was caused by flood. And they're going to ask him, how do you know that? And he's going to say, I looked at photographs. Now, at a minimum, we're entitled to know what photographs. And this goes back to the point that we aren't digging through counsel's email inbox. Mr. Rennie made these immediately and critically relevant by sending them to us at 12:02, except for the header, and saying, oh, I also relied on this. We're entitled to know the details of these photographs because that's the only thing we're going to be able to challenge at trial under the existing Daubert ruling. And just as importantly, as I mentioned, if this is the case, if he really did go back and find them, well, then that would explain his confusion at the beginning of the deposition that he only relied on the 2 interior photographs. But if that is not true, if it is not true that this thing he sent us to prove he looked at 154 photographs, if he did not have that back when he issued the opinion, like he testified when he was trying to sort of recant his initial testimony, that is a critical piece of impeachment on his credibility. If he misrepresented that fact, there's no way we will be able to prove that on plenary appeal. We won't have the information. So I won't be able to tell you the impact that would have had on the jury. And we cite a couple cases in our reply for the point that this type of missing critical impeachment evidence of an expert independently warrants certiorari review. Because again, how am I going to come here on plenary appeal and tell you, he misrepresented something in his deposition that we could have read to the jury, but now we can't? That is the quintessential kind of missing information that we need to be able to present to the jury at trial. And there's no other way we're going to get that. I'll touch briefly on the response, which again, it makes no effort to defend these redactions.
And before you get into that, I'll point out that you're heading into your rebuttal time. So use the time as you wish.
I'll reserve my time.
Ms. Martinez.
Mr. Martinez, you are muted, sir.
Thank you. Sorry.
Do that all the time.
May it please the court. Thank you. Members of the court, we're arguing about a ruling that the court never made. The court's ruling was that she reconsidered a previous decision to compel Grant Rennie to look for other emails that he may have had. The trial court never said the ruling was based on a finding of privilege. The order from which United UPC appeals is also silent on the reasoning. And we had given her another reason to deny it in our response because we argued Rule 1.280 does not require disclosure. That could have been the basis of her decision. But more importantly, this is a case where UPC opened coverage on a first-party insurance claim. They paid the
Before
roof.
you leave your last point, forgive me, I was still
Yeah.
muted. When you talked about the trial court's order, and looking at the order we have on appeal, the denial, and I was preparing for today, I came across an opinion from this court in Gia Coloni, authored by Judge Wallace, and it explained that there was an order that had no explanation of its decision, denying individual discovery request, and such a denial of relevant discovery is an insufficient order. Should we address the insufficiency of the order, or has that been waived because no one has really argued it?
Our position is that it's been waived. No one's argued it. Certainly the appellants.
So then I noticed that we're talking about what the court didn't do. Then if it's waived, it doesn't really matter what the court didn't do. We just follow with Judge Northcutt, right?
Yes.
The line of reasoning he was putting forward. Because I was just concerned that this order may not be sufficient.
Right. That our position that's never been argued. But insofar as the facts of this case, the insurance company opened coverage. They paid for the roof. They paid for the entire roof because it was damaged by Hurricane Irma, and it was extensive damage. And they paid under $1,000 of interior damage. And they sent 3 field adjusters out to the property, and they decided to pay those monies. And so they are claiming that the floodwaters that came into that house, which were only 2 inches of surface water, which receded after a few hours, that flood company should pay for those damages. However, the problem is that above those 2 inches and above, 2 feet, which is sort of the industry standard for, for what's a surface water versus what's wind damage. Above 2 feet, there was a lot of damage. There's damage to drywall, which is not something that can be documented by way of a photograph. There was damage to windows. There was damage to kitchen cabinetry, damage to air conditioning units, HVAC systems. And so there was a lot of damage to this property. But, we don't even need to call Mr. Rennie as an expert in this case, because the fact that the insurance company opens coverage for a roof that is damaged and is allowing rainwater to enter the home during the hurricane, and there's obviously extensive damage, we wouldn't even need to call him as a causation expert. I think the jury would understand that water doesn't travel upward, it travels down. And so that rainwater that came, or those damages that are above 2 feet in that home, had to have been not from surface water, but rather from rainwater coming in through the damaged roof that the insurance company paid for. Insofar as what Rennie reviewed, he didn't just review these 154 photos that he testified during the deposition. He testifies during that same deposition that he reviewed 200 photos from a field adjuster from the insurance carrier, and that's not disputed by the appellant. And at any time, not during deposition, not in their brief before this court. He also reviewed motions for summary judgments, exhibits, hurricane data, repairs and receipts. He spoke to the Millers. He looked at photographs provided by the Millers. And I've mentioned the 200 photographs from the UPC field adjuster, but there's a number of things that he reviewed informing his opinion. And insofar as the testimony that has been attributed to Mr. Rennie, I would suggest to the court that a full reading of his deposition would really shed light on the fact that he didn't change his story. He was just very specific about the question that was being asked. And on redirect, he said, look, I have, 4 photos in my report, and I didn't just draw them. Those 4 photos came from somewhere, and they came from those 154 photos that they're now claiming that Rennie didn't have up until the time of the break of that deposition. So our position is that petitioner, they failed to show that there's been any denial that their defenses have been eviscerated in any way. They haven't demonstrated irreparable harm, that they haven't even identified a defense, let alone demonstrated how the defense is eviscerated if it is hampered in its ability to cross-examine Rennie when he received 150 of the more than 350 photographs that were taken in this case. Our position is that this petition should be denied on that basis. Certainly, they'll have a wide latitude in cross-examining Mr. Rennie. The trial court actually in its order said I'm going to grant them wide latitude to explore all of this, to cross-examine Mr. Rennie at length about it. And we welcome that cross-examination. It sounds from his arguments this morning that he's going to have plenty to talk about and to cross-examine Mr. Rennie about, but these are issues that are not appropriate for cert review, but rather for appeal after a jury verdict. And I thank your honors for your time.
Thank you, Mr. Martinez. Mr. Chilness, you're up.
Thank you, Your Honor. I want to touch briefly on Judge Casanueva's concern about preservation. Obviously, trial court's oral pronouncement and oral discussions during the hearings inform the final order. If you track the hearings, there were 3 pertinent hearings. You can tell that the arguments that were advanced were attorney-client work product. That's the redaction on the face of the email we need, and that is in the privilege log. And if you track those.
And I was just wondering whether there was any issue on the sufficiency of the order and whether we had to address that or not. And as pointed out, no one has raised it. So I just wanted to be clear on that it hadn't been raised, and we'd go on with what we had before us. Because if it's the form of the order that precludes review, then that would be different, I think, than what we are posited right now.
Yes, thank you, Your Honor. And I believe that the attorney-client work product was the basis for the ruling. We've addressed the other argument that counsel pointed out, 1.280. This information is certainly discoverable under the rules. We track that in our brief. But the most important point I need to get back to is why this matters, why I'm asking you to issue a decision in this case. Mr. Rennie is basing his opinion on something that's very thin. And at trial, we need to know exactly what he relied on, what he said he relied on. And the attorney-client privilege, work product doctrine, those are really important and storied doctrines. They by their almost definition stand in the way of relevant discovery. We have yet to hear any defense of the redaction of this header as attorney-client privilege or work product. And it comes back to the fact that Mr. Rennie is the one who gave us this document. So I am relying on this, but he refuses to tell us the header of that email. When did he get it? Who sent it to him? And when? That is all something we're entitled to discover. The other side of these really powerful protections and privileges is that they should be used correctly and judiciously. At the end of the day, again, that's the most important question I have. Why redact just the headers? There's information there that is highly relevant to us. We need to know which photographs he looked at, which ones he didn't. And he said in his deposition, my memory is refreshed now that I see this. Well, we need to know what it was he saw. We need to have that ability at trial. If he doesn't testify live, nobody's going to be able to cross-examine him. They're just going to present his deposition.
Did he not in that deposition say, I saw these?
It certainly said that after the break, but before it, he did. Before that, he testified.
During the deposition, you had the opportunity to cross-examine him then.
But he contradicted himself, and we didn't know what that document said at the time. So we received it at 12:02. Well, Your Honor, we asked him, when did you get this? And he says, I don't know. I don't remember. I deleted the email. The header of that document will tell us the answer to that question. So he did not answer our question. He redacted it as attorney-client privilege work product and refused to give it to us in that deposition. So we did not have a fair opportunity to cross-examine about it. And if he doesn't show up at trial and they rely on that transcript, what are we going to do?
Well, I suppose you could read the parts where you cross-examined him on that.
But we didn't have the information. We still don't. We still don't know when those photographs were sent to him. He redacted it improperly as attorney-client privilege or work product. And if we go forward without this, we have no remedy on plenary appeal. So we're asking the court to grant us certiorari relief so we can have this information for the trial that's set next month. Again, what we're asking the court to do is to give us the information we need to impeach this opinion. This opinion is unusual. It's based just on photographs. And at that deposition, before he changed what he was testifying about, he committed unequivocally that these were all the interior photographs he had. We asked him to go back and check. He went back and checked. He testified under oath. That's all I've got. We asked before the deposition, if you sent us everything you have. Yes. So it's not that he went back and remembered. He's contradicting his sworn testimony after the deposition break. So
from heaven for you, Mr. Chidneys.
Come again?
Isn't that manna from heaven for you?
Well, not at all, because we don't know if what he said later is true. We can't prove when he got these emails that this redaction stands. And the jury may well believe his story that, well, now I remember these additional emails. We are absolutely entitled under the rules of discovery and evidence to know when he got these new emails. And if he misrepresented before the break that he gave us everything he had. He may well have done that. We believe he did. We believe he sent us everything he had, and we gave him plenty of time to go back and look for more interior damage photographs. All of a sudden, he shows up after a 5-minute break with 154 new photographs. And he sends us on his own. Again, this is what it goes back to. He made this at issue. He made this extraordinarily relevant.
Photographs that he looked at that were taken by your adjusters, your investigators.
Sorry, come again?
How many photographs in total had he looked at, or did he had access to before he filed the report?
Before he filed the report, he testified that the only site inspection he performed were the 8 photographs attached to his report.
Right.
That's what he was relying on. He did not say before that break that I looked at these 154 photographs. He never said that. He said that after the break. Before the break, he said, I have 8 photographs, 2 of them.
Photographs taken by your adjusters?
The photographs that were attached to his report?
No, the photograph, had he looked at the photographs taken by your adjusters?
No, he did not testify to that until after the break. After the break, opposing counsel said, does this refresh your recollection as to whether you've seen it? And of course, he says, yes, of course, I looked at all those. He was asked, why didn't you include them? He says, I don't remember, or I included these 2 photographs because they were better. But he doesn't mention those 154 photographs ever before that break. In fact, he commits that he's given us everything he has. He's given us all the interior photographs and says only those photographs support his interior opinion. It's only after the break.
Your time is up.
Thank you for your time.
Thank you both. In order to leave the virtual courtroom, you need to click the button called Leave on your Zoom screen. And you disappear into the ether.
Thank you, Your Honors.
Thank you, Mr. Martinez. Okay, the court will be in recess for 10 minutes. Don't see Judge Casanova, do you?
I think he was there a minute ago.
There,
There he is. I saw him earlier.
we were worried about you, Judge Casanova. Nice to see you alive and kicking. Okay. The next case are the Clutchers versus Clutcher. There he is. All right. It's kind of like old home week with Mr. Bowen and Mr. Baseman.
Yeah, I'm afraid so.
All right, Mr. Bowen, you're up.
All right, Your Honor, most of what I'm going to say is in my brief, and I want to rely on my brief. The only one I really want to talk about is arguments 1 and 2. The arguments 1 and 2 are, I think, pretty obvious. They have a former wife who earns more money than the former husband by significant amount. She has significantly more assets in a retirement plan, like 5 times the amount. And she also has the $4,600 in 3 bank accounts. And based on my client, who only has the $2,500 in alimony and the Social Security, the court awarded under 6116 that my client owed the former wife money, which doesn't really make any sense. Now, one of the things that's been argued in the briefs is Rosen, but Rosen is never mentioned in the order, nor is it mentioned in any of the testimony or arguments before the court. What was argued was an inequitable conduct, which is a different animal all in and of itself. In any case, though, is that the amount that's there is clear, that there is no, that my client, the former husband, did not have the ability to pay. The use of assets, the $30,000 that was owed by the former wife, is not appropriate in this particular case because there is no shown need in this matter. So that's really on the 2 issues that were there. That's all I've got for right now. I'll save the rest for rebuttal.
How about I give you like 5 minutes for rebuttal?
Okay.
Okay. I may let you expand that a little bit. Mr. Baseman gives you a lot to talk about, but don't want to give you like,
No, I won't take it either.
Okay, Mr. Baseman, you're up.
May it please the court. My name is Mark Baseman on behalf of Sherry Clutcher, now goes by Hayes. If we're only arguing the attorney's fees, I think the core of my argument, look, I'm not going to disagree that my client has superior assets, superior income. That's not the question. I think the question is, how seriously do we take Rosen and this court's more recent cases interpreting Rosen? To quickly deal with the idea that Rosen wasn't mentioned or argued. I do believe Rosen was argued in the motions that originally asked for fees, but either way, Rosen merely interprets 6116. It doesn't create cause of action.
Rosen actually wasn't mentioned in Rosen.
Well, that's a fair point. But again, it is 6116. It just tells us how to look at it. And Rosen says, yeah, we start. Rosen says, yes, you have to consider the financial resources. It says you can't do a fees award under 6116 without considering the financial resources. But then it says there are other things that must be considered. And 2 of those are the history of the case and the length of the litigation. Frankly, it doesn't even say whose fault the length is or whose fault it is to the history, but it says to consider those things. I cite this court's decision in Rogers v. Wiggins. And just to address something that shows up in the appellate brief, Mr. Bowen correctly argues that in the 4th district, the Hahamovich opinion really does seem to draw a black line that says the logic of Rosen cannot be used to make the poorer spouse responsible for the wealthier spouse's attorney's fees. I don't doubt that. I think that's a clear rule in that district. As far as I know, none of the other districts have accepted that rule. And I cite the Rogers case because our court says that. It says, although Rosen states a trial court has discretion to deny fees to a party that engages in excessive or bad faith litigation, cases have interpreted it to authorize fees against a party for such conduct. In that case, and in other cases in this district dealing with Rosen, they still say that there has to be a finding of ability to pay. But there seems to be some sort of between the lines argument going on here that when conduct is bad or when one party causes the litigation, the key factor is more the ability to pay than need. The idea being that parties shouldn't suffer just because they have the greater ability to pay. In this particular case, there's no way to say there wasn't a literal ability to pay attorney's fees. The court found that. The court was awarding a sum of money to the former husband, and from that deducted the attorney's fees. And my position is that the case law in this district goes in that direction. That once you trigger Rosen, once there's a finding by the court that this case has gone on too long, that there's inequitable conduct, whatever you want to call it, once the court finds that, it then can award fees if it can find a literal ability to pay. The idea being that if somebody's truly destitute, it's completely inequitable to make them pay. But here there is an ability. And in my view, the trial court reviewed the file, found at the very least that this case has gone on way, way, way too long. I mean, the entire purpose of this March 10th hearing was for the trial court to put its foot down and say, this litigation has to stop. These people have not stopped in 7 or 8 years. And one of the methods the court came up with was awarding attorney's fees against the former husband. Clearly an ability to pay. Now, look, the court also found that there was a need on my client's part because she was living at a deficit. Again, relative financial circumstances, there's no question. My client is in a better financial position. But we think you take Rosen seriously when it says 6116 is supposed to be construed liberally. It's supposed to give the trial court broad discretion to do equity in these cases. Trial courts have the discretion and the obligation to control their courtroom and to control the litigation. And I think it was well within the court's discretion to decide to award fees under these circumstances where there's a clear ability to pay. Is all I would put forth unless the court has questions on this issue. And I'm obviously happy to take questions on the other issues as well.
You don't get points off for not using all your time. All right. Thank you, Mr. Baseman. Mr. Bowen.
Yes. I guess he's saying is that my client had the ability to pay because the former wife has failed over 6 years to pay $30,000 of equitable distribution that she was required to pay. But I don't think that first of all, a lot of Rosen cases come where the trial judge actually heard all the arguments that were being made throughout the case. In this case, this judge just got into the case and then he ruled, I've reviewed the docket, and the docket shows the case is going on too long. There is no indication that my client is the fault. Matter of fact, if the case is going on too long, it could have been set by the other side just as easily as set by mine. But the fact remains is that my client filed a motion because she did not pay karate expenses. And that karate expenses were awarded to my client, not all of them, but awarded it. She had not paid any. So I don't know how that could have been a inequitable motion to have filed. In addition to that, we had the other case, the other order, and in that other order, it said that that it was a creeping expense. Well, creeping expense would seem to me to mean that the expense has gotten a lot more than what it was at the time of the final judgment. But there was already an order in place under a prior judge where that judge held that that the former wife was necessary. It was necessary for her to pay for this child to go to the international event, which seems to me to be res judicata. I don't see how that also is the filing of a reconsideration just to make sure that the judge understood the argument is a inequitable conduct. And if you look at it, the wife has filed a bunch of motions. She filed a motion for termination of alimony because she was going to have a reduction in pay. But it turns out that she actually had more. She made more than she ever made before. So I don't know how a judge can sit there and say, I've reviewed the document. This case is going on too long, and I'm going to go after the former husband when there is absolutely no evidence and no facts in the final judgment or in the order that indicates in any way what the former husband did that was inequitable or was not correct and would be subject to Rosen. That's fine.
Okay. Thank you both. On your Zoom screen, there is a button called leave, and that's how you leave. So click that. You'll be gone.
Thank you.
Thank you both.
both.
Okay. The next case is Commons versus Spracklin.
Judge Northcutt, we just need the attorneys to turn on their cameras.
Okay, I see one, see two. Okay. So you're up.
Thank you. My name is Desiree Banish. I'm here on behalf of the appellant, Linda Commons. May it please the court. This case arose from the lower court's denial of a charging lien that was filed by Ms. Commons because she had not been paid her attorney's fees. The amount of attorney's fees that's in controversy here is $88,600. The remainder of the fees had been paid as a result of a prior settlement. The entire settlement was $1,055,500, and that occurred in two different settlements. The first check went to Mr. Price's trust account, and he dispersed those fees to Ms. Commons appropriately. Then the second check was supposed to go to Ms. Commons' trust account, but Mr. Price arranged with defense counsel, unbeknownst to Ms. Commons, to have that settlement check sent to his trust account for the purpose of that money being in his possession. There were 3 hearings on this matter. There was a case management conference and a motion to compel. And during both of those, Mr. Price was claiming an hypothecation as his right to a portion of Ms. Commons' fees. By the evidentiary hearing that was noticed by Ms. Commons, he filed a response a day and a half before the hearing, changing his theory of the case to a retaining lien. Mr. Spracklin had been subpoenaed to come to the hearing, and once there, upon the prompting of Mr. Price, Mr. Spracklin claimed attorney-client privilege and refused to testify and refused to allow documents to be entered into evidence to prove up the charging lien.
Ms. Banish,
Yeah.
seems to me that there are 2 conflicting, inconsistent theories in the case, one by your side, one by the other. Your side is you're asserting a charging lien on property of the client.
That's correct.
And Mr. Price's side is asserting a charging lien, a retaining lien on your property.
Correct.
So it seems to
Ms.
me
Commons' property.
Oh, yeah, on your side's property. It seems to me that if this case is going to be resolved on this issue, one of the things we have to decide in court is who owned the property in Mr. Price's trust account.
That is correct. That is the crux of the entire case.
Now, let me ask another question, though.
Yes.
Has your client sued? I don't recall the fellow's name. The personal injury client,
Mr. Spracklin.
Mr. Spracklin, rather. Has your client sued Mr. Spracklin for fee?
No, the case law has stated that it is better for the fee issues to be resolved in the case so that, confidentialities can be maintained.
Well, of course, so far that hasn't happened.
Well, she did assert a charging lien, and that's why we're
Your
here.
client, charging lien aside, it's not necessarily inconsistent with the charging lien for your client to sue Mr. Spracklin for her fee, correct?
Correct. She can do so. I guess that will depend on the outcome of this case. The issue of who owns it seems to revolve around of when paid is paid. The lower court held that because Mr. Spracklin signed a settlement statement allocating the fees to Ms. Commons, that Mr. Spracklin paid her fees. But decades of case law conflicts with that, saying that paid isn't paid until legal tender is transferred and all rights of the previous possessor have been extinguished. Once a check is delivered, the person that wrote the check could stop payment or somehow withdraw that. So it's once the check has cleared, then payment is made. There was no payment. There was a check for $61,000 and change that was sent to Ms. Commons by Mr. Price, who is the fiduciary trustee in this matter, responsible for paying Mr. Spracklin's legal bills. He's the one that has asserted a retaining lien.
Ms. Branish, can I circle back to what Judge Northcutt was asking earlier?
Yes.
Procedurally before the court, we understand that both sides are making claim for this money. And my understanding of the fact, this was set for an evidentiary hearing before the court to say, hey, we have this dispute, help us out. And am I correct that at the evidentiary hearing, you had the opportunity to call, Mr. Spracklin? I'm looking at the transcript. There was really no evidentiary hearing conducted in terms of taking testimony or putting him under oath saying, you know, that this is my fee. Do you have any problems with the fee? Nothing like that. I think it was only legal argument. The court afterwards made some comments that said, yeah, your client probably is entitled to that, but based on the record before me, came to the conclusion that she was not, that the judge was not able to do it at that juncture. So having said all that, up here on appeal, when we review the court below, when we see there was an evidentiary hearing, but there's no evidence presented, help us out here, Ms. Brandy.
Okay, and you are correct in that, and it was one of the issues that have been brought up in the briefs, in that we tried to have an evidentiary hearing, but the Mr. Spracklin, upon the prompting of Mr. Price, said that he was not waiving his attorney-client privilege against his attorney. It didn't make much sense. But the court went with that, and then the court kind of took it away from evidentiary hearing and said that she believed that she could decide this as a matter of law. She did put Mr. Price under oath, and he testified as to what Mr. Spracklin, who was right there, was thinking. Instead of Mr. Spracklin testifying to it, Mr. Price told us what was going on with in Mr. Spracklin's mind. We were not given an opportunity to cross-examine or really put on any evidence. She just ruled as a matter of law. And that's why we've claimed that this is the standard of review here is de novo. It was claimed that the ministerial act of signing a settlement statement equals payment, and that was the reasoning behind the court's finding that there was no charging lien because Mr. Spracklin had not avoided payment, and that was based upon argument / testimony of Mr. Price. It was rather confusing because the court was asking Mr. Price questions under oath, but also allowing him to argue. And so it's confusing as to what was testimony and what was argument. I would say that there are several reasons why there is a charging lien and why there is not a retaining lien. First of all, the court rather passively granted a retaining lien to Mr. Price, even though she admittedly didn't have jurisdiction to do so. A settlement statement is not payment. A settlement statement is a direction to the fiduciary to pay Spracklin's bills according to how it is delineated in a settlement statement. It doesn't become the property of Ms. Commons upon his signing, so that Mr. Price then has possession of Ms. Commons' fees to assert a alleged retaining lien for an alleged bill that Ms. Commons feels she does not owe at all. A bill that was sent to her over a year after the alleged work was done, and he attended one hearing and gave a bill of $35,000 discounted to 27, and said nothing about it until he asserted this hypothecation And then when he couldn't meet the elements of a hypothecation, changed it to a retaining lien just before the evidentiary hearing. So we had prepared for the hearing for a hypothecation argument and got a totally different one, and a client that was claiming attorney-client privilege to avoid testifying. It's clear that Mr. Spracklin, because part of the argument was that Mr. Spracklin is out of this, he's innocent, he has no part in it. But when he came to that hearing and refused to testify against his, as a neutral person with two attorneys, but took sides, he was an active participant in avoiding payment to Ms. Commons in favor of Mr. Price. That satisfies the element of a charging lien. The partial payment that Mr. Price sent to Ms. Commons for, I believe, $61,000, because he's complaining, he's claiming $27,000 he is owed, was had a note on it that this was her fees for this case. It doesn't say partial payment or anything like that. So Ms. Commons couldn't cash that check. So so she's asking that she be given that the lower court, that this case be remanded for to also determine what is the interest that's owed on the entire amount. Now, it's true that Mr. Price has said that he would not assert accord and satisfaction in this case, but he has also filed a case against Ms. Commons in Miami, and it is clear that he is going to claim accord and satisfaction in the Miami case should she cash that partial check. So she has been deprived of the entire amount for quite a while now. Mr. Price, this was also a paycheck, and a paycheck is treated differently. For a paycheck to be intercepted between an employer and an employee, that must go through a garnishment action. And here there was no such thing. That he took her paycheck and didn't go through any of the proceedings. And it matters how he came into possession of the funds to establish a retaining lien. It's not an acquiring lien, it's a retaining lien. And Mr. Price manipulated the situation to obtain those funds in his trust account, whereas it was supposed to go into Ms. Commons' trust account. And he did that for the purpose of being in possession of her fees so that he could claim it. Mr. Price had a conflict of interest. He was wearing two hats that the lower court in the first two hearings had a problem with. She had a problem with him wearing two hats, the hats that is looking after Mr. Price and Mr. Price's firm's best interest, and the hat of the fiduciary that is supposed to distribute the funds on behalf of his client, Mr. Spracklin.
Ms. Banish, I'm sorry. You didn't mention whether you wanted to reserve rebuttal time. You are down to 5 minutes and use them as you please.
I will take the rest for rebuttal. Thank you.
That's fine. Mr. Grossman, you're up.
Yes, thank you, Your Honor. Dennis Grossman of the Law Office of Max Price, appearing on behalf of appellee James Spracklin. First, I just want to address Ms. Banish's claim that there was no evidentiary hearing and no opportunity for Ms. Commons to put in evidence. That's just not true. On record page 318, which is transcript page 15, the judge, after swearing in Mr. Price and after hearing Mr. Price's testimony, the judge turned to Miss Banish and said, well, I'm now giving you guys, speaking to Miss Banish and to Miss Commons, I'm now giving you guys an opportunity to put in whatever evidence you want. They had subpoenaed the plaintiff, Mr. Spracklin, to appear. He appeared pursuant to the subpoena. He offered some attorney-client objections to specific emails, to specific documents. He asserted an attorney-client privilege. He never said, nor did Mr. Price ever say, that he's not going to testify totally. They just never called him as a witness. They had full opportunity to do so. They never did. They had full opportunity to put Miss Commons on the stand and never did.
But did Mr. Price testify that he was holding the funds on behalf of Miss Commons and not Mr. Spracklin?
Yes, that was exactly Mr. Price's testimony, and that's the
is his version of that binding?
It should be, because there's no contrary evidence.
Well, I'm not sure it's an evidentiary question. We know beyond knowing that the funds came into him as part of a settlement proceeds for Mr. Spracklin's case, and that Mr. Spracklin owed fees to his attorneys, including Miss Common. I'm not sure that Mr. Price's view that he was holding it on behalf of Miss Commons and not on behalf of Mr. Spracklin is really legally correct.
Well, it's the only evidence there. The burden here lies upon the movement, upon Miss Commons, who is asserting a charging lien. It's her burden to prove her case that a charging lien existed. I went over the transcript again last night. After the judge told Miss Banish and Miss Commons that she is letting, in the judge's words, you guys put on whatever evidence you want, Miss Banish, after that point, Miss Banish spoke no less than 20 times on the record of the hearing. Not once did Miss Banish call Miss Commons as a witness. After the judge told Miss Banish, you guys now have an opportunity to put in your evidence, Miss Commons, the appellant herself, spoke 5 times on the record. Not once did she say, Judge, I'd like to be sworn in and testify that those funds were not mine. The funds clearly, and the movement, Miss Commons has not proved otherwise. It's her burden of proof. The funds clearly in Mr. Price's trust account, where that's disputed $27,000, was clearly Miss Commons' property. Once Mr. Spracklin signed the closing statement, the settlement statement, once he signed that, it was Mr. Price's obligation to treat it as Miss Commons' property. That's the nature of a settlement statement.
Or was it his obligation to Mr. Spracklin to pay the fee that Mr. Spracklin owed to Miss Banish?
No, it was his obligation to treat it as Miss Commons' property.
And your authority for that is?
Basically the nature of a settlement statement. It's the nature of a settlement statement that it's Miss Commons' property. There's no doubt that it was Miss Commons' property once Mr. Spracklin signed the closing statement saying, this is the money I owe to Miss Commons. If Mr. Price had not treated it.
So if Miss Banish sues Miss Commons sues Mr. Spracklin saying, I haven't been paid my fee, he will say, oh, I need to third party Mr. Price because Miss Commons' fee is in his possession and he won't pay it.
Well, but that's an issue that's going to be resolved in the already pending action that Mr. Price has commenced in circuit court. It was transferred to county court.
Did he submit Okay. Did Mr. Spracklen sue Mr. Price?
No.
And
Mr. Price sued Ms. Commons. She has filed a pending motion, I believe, to dismiss. Assuming that's going to be denied, I'm informed that it has not been resolved yet. Ms. Commons has an opportunity to counterclaim against Mr. Price. And Mr. Price, indeed, he made a motion in this court, in the trial court in this case, to deposit the $27,000 into court. He said, look, I want the court to control this money. I don't want to run off with this $27,000 if ultimately it is determined by some court that I'm not entitled to it. Mr. Price says, I'm entitled to this. I've asserted a retaining lien against it. The Moniz case in the Florida Supreme Court supports my retaining lien. But if it turns out that I'm wrong, I don't want to be accused of any wrongdoing. Please, court, accept this deposit into court. That motion for Mr. Price to deposit the disputed $27,000 into the circuit court in this case was denied by the circuit judge. She said she had no jurisdiction over it. That's a matter between Mr. Price and Ms. Commons that's going to be resolved in the already pending lawsuit in Miami-Dade County commenced by Mr. Price against Ms. Commons. Mr. Price can go there and deposit the money into court. Mr. Price has committed that he'll be more than happy to deposit the money into court.
That hasn't gotten Mr. Spracklin's obligation to Ms. Commons paid, though, correct?
But it will if the court determines that Ms. Commons is owed the money. Mr. Price submits that, with all due respect, that she's not owed the money. That's why he asserted the retaining lien. But if a court determines that Mr. Price is not owed the money based upon arguments between Ms. Commons and Mr. Price would love to be able to deposit that money into court. And as I mentioned, he tried to do so in this case itself, but it was denied. And if Ms. Commons,
if I may, Mr. Grossman, because it becomes a little, I'm sorry, can you hear me? It becomes a little confusing.
We can't hear you very well, Judge Casamay.
I'm sorry. Did I jump in? I apologize. I did. If you have a question, I'll wait, Judge Casamay.
No, go ahead. You're farther along than I am.
Okay. I guess where the confusion comes up, Mr. Grossman, in this lawsuit, the lawsuit that is now on appeal before us. The matter was set for evidence hearing before the court. And as I understand it, is Ms. Branish was trying to say that her client is entitled to that money because she had earned that money in this case. And as I understand, your client, Mr. Price, basically saying, yeah, she's entitled to that money. However, she owes me money on another matter, and I don't want to disperse all this to her because I'm entitled to get paid on some other case that she owes me. That's the problem that I guess I'm having a problem with. If there's no dispute that her client is entitled to receive her attorney's fees representing Mr. Price's client, Mr. Stratton, isn't she entitled to receiving that?
she's entitled to that money subject to the retaining lien which Mr. Price properly asserted pursuant to the Florida Supreme Court's decision in the Moniz case, which both sides have cited. The Moniz case is directly on point.
Well, let's talk about Moniz for a moment, if we might. Is Mr. Price's contention is that Ms. Commons was his client, or was the client the person he entered into court a notice of appearance for?
Mr. Price was the attorney assisting Ms. Commons in the unrelated case. It was the Chapman case.
They were representing Chapman?
Ms. Commons was representing Mr. Chapman, and Mr. Price was representing and assisting Ms. Commons in that case.
So he's saying that Ms. Commons was his client?
Ms. Commons.
Now, under Moniz, it has to be a client. So the answer is yes, that She's his client.
Yeah, yes, in the Chapman case,
Does that
Mr.
strike you as a
Price-
bit of a stretch that co-counsel has the other counsel as a client?
Well, no, that can often happen. I mean, it might not happen, it might happen, but that's exactly the type of issue that's going to be decided by the Miami-Dade Circuit Court upon Mr. Price's assertion of a retaining lien. Judge Casanueva, you've addressed issues which are pertinent to the existence of a retaining lien. I understand your question. Twice on the record, and I'll cite you specifically, on transcript page 15, that's record page 317, Ms. Banish said that all issues of a retaining lien are for another court. She was referring obviously to the Miami-Dade action pending between Mr. Price and Ms. Commons. Again, on transcript page 31 at record page 321, Ms. Banish says the retaining lien issues are not within the jurisdiction of this court. And the judge in this case agreed with Ms. Banish. And the judge in her order stated this court has no jurisdiction over all these retaining lien issues, exactly as Ms. Banish argued. So Ms. Banish prevailed on that issue, that all these retaining lien issues, which Mr. Price has asserted, and about which Your Honor, Judge Casanueva has inquired just a few minutes ago, all these retaining lien issues are not within the circuit court, and the circuit judge agreed with Ms. Banish on that. They will be resolved in the Miami-Dade Circuit Court. As to the charging lien issue, which is within the jurisdiction of the circuit court in this case, clearly, once Mr. Spratlin signed the closing statement, the settlement statement, committing Mr. Price to treat that as Ms. Commons' property, Mr. Price then went ahead and asserted a retaining lien, the validity of which, by Ms. Banish's own argument, is not within the jurisdiction of this court in this case. The circuit court agreed with Ms. Banish. That issue is going to be resolved by the Miami-Dade Circuit Court, and Mr. Price will be more than happy to deposit that money into any court which will agree to accept the deposit to secure Ms. Commons' claim should she prevail against Mr. Price. As to Ms. Banish's argument.
If
Yes.
I may, Mr. Grossman, because I'm pulling up, and then the transcript, didn't the court at one point said, and I quote, "It seems to me that if she is owed a fee for this case, I rule on that and she gets her fee from this case." So the judge acknowledged that she's entitled to her fee. Then there's that argument of that tangential other case that Mr. Price is claiming that he's owed on. And so then there was a mishmash. There was no, it should have been clearer in an evidentiary setting to put Mr. Price under oath, to ask him question about, there's no question, I guess what I'm trying to say, that she is owed a fee in this case. And the big dispute, are we clear on that?
Absolutely. Ms. Commons earned that fee. That was her money in this present case. Absolutely clear. No dispute about that. And because it was her money, Mr. Price then asserted the retaining lien. As to Your Honor's inquiry regarding the clarity of the evidentiary hearing, it was clearly an evidentiary hearing. She swore Mr. Price in as a witness. He just didn't argue as counsel. He swore and he testified under penalty of perjury. The judge expressly stated on the record to Ms. Banish that, quote, "I'm going to let you guys, quote unquote, put in your evidence now." Ms. Banish thereafter spoke 20 times on the record, never calling Ms. Commons as a witness, never cross-examining Mr. Price. Miss Banish spoke 20 times. Miss Commons spoke 5 times, never saying, "Judge, swear me as a witness." Miss Banish, on behalf of Miss Commons, never called the client, Mr. Spracklin, as a witness. Mr. Spracklin asserted attorney-client privilege regarding a couple documents, but he never said he was going to refuse to testify. He was there. He was ready to testify pursuant to subpoena. He was never called as a witness.
Mr. Grossman, let me ask you something on a slightly different matter, if I might. In examining the copy of the complaint filed in Miami, that's in our court file, so I acknowledge that it may be dated or superseded. Count 1 is for a breach of contract. Count 2 is for quantum merit. Count 3 is for open account. There is no count to foreclose a retaining lien on any corpus of funds. So without such a pleading, how does the court in Miami address it?
The court addresses it on the merits, and whichever way the court
Aren't
decides.
merits determined by the corners of the pleadings?
Yeah, but the pleadings aren't finished.
That's what I'm asking. Right now, there is nothing about foreclosing a retaining lien on a corpus of funds. So you have represented, it will be taken care of in Miami, and I'm looking at the counts that appear, and I'm wondering how it's going to be done based on the present status, the record that was before this trial court. And there's nothing in there that I could see about a retaining lien.
If there is a requirement to foreclose on a retaining lien, I'm sure Mr. Price will seek to amend his complaint. I note that Miami-Dade action is in its early stages. I believe an amended complaint was filed, and in the early stages of the case, I'm sure Mr. Price will amend the complaint in whatever way is necessary if there is a technical procedural deficiency in that complaint. And given the liberality of amendments.
I understand. I just wanted to make sure I followed the argument that there was something in this complaint that the trial judge had before at the time this case was resolved, that somehow it might resolve the question of a retaining lien. And I guess what I understand is that if it doesn't, you're prepared to make sure it does.
Yes, exactly. And at the early stages, again, Ms.
I understand. Great liberality. Great liberality. I was a trial judge for 7 years. I remember that argument.
All right, I understand. As to Ms. Banish's argument that she could not, that Ms. Commons could not cash the $61,000 check, that's just totally baseless. Mr. Price has consistently stated, and he even submitted a proposed order to the trial judge in this case, that Ms. Commons can deposit that check without prejudice. She wants to raise whatever arguments she wants to raise. There won't be any accord and satisfaction anywhere. It's totally without prejudice to her rights. But what Ms. Commons is trying to do is she's trying to hold back, claiming she can't deposit that $61,000 check, which she in fact can without prejudice, because she's seeking to use that as a basis for her treble damage civil theft action. Ms. Commons, and it's in the record, has served Mr. Price with a letter giving him alleged notice of a prospective civil theft treble damage action in which Ms. Commons seeks to treble not $27,000, the disputed sum, but rather she seeks to treble $88,000. And she is purposely going out of her way not to deposit the $61,000 check, which she can without prejudice. Mr. Price mentioned that in his emails and proposed order at the trial court. He's mentioned that in his answer brief in this court. I am again reiterating that commitment that Ms. Commons can deposit that $61,000 check without prejudice to whatever arguments she wants to make with regard to the $27,000. So again, through all the retaining lien issues, which Your Honor, Judge Casanueva, which you mentioned regarding a retaining lien, are not before this court. They are not, the trial judge has no jurisdiction Ms. Banish twice argued that in the transcript. The trial judge agreed with Ms. Banish. All those issues are going to be decided in the Miami-Dade court. The charging lien, Ms. Commons failed to satisfy her burden. She had an opportunity to testify. She made arguments. There was absolutely no evidence whatsoever, none whatsoever.
Okay, Mr. Grossman, I thought you were starting to wind up because your 20 minutes are up. You seem to start, you seem to be cranking up again. So I'm going to.
In conclusion, there is not only more than enough competent, substantial evidence to support the trial judge's decision. That's the only evidence in the record. It supports the trial judge's decision. This court should affirm in all respects.
Okay. Thank you. All right, Ms. Banish, you have 5 minutes for rebuttal.
Thank you. I would like to first address Mr. Grossman's statements that Mr. Price has stated over and over that Ms. Commons would not be in fear of accord and satisfaction. It is clear in the record that he said that she would not be held to accord and satisfaction in this case, in this charging lien case, in this case that is styled for Mr. Spracklin. He specifically did not include the Miami case, which is where accord and satisfaction would be most important. If he went down there and said, oh, well, she's already cashed a check that says that this was her fee, she's accepted that, and she has waived her right to the other $27,000. Since he would not, and he'd been given many opportunities to stipulate that it would not be in accord and satisfaction as well in the Miami case, he has refused to do so. Mr. Spracklin, I'm fairly sure that he was put under oath, and I began questioning him, and he immediately claimed attorney-client privilege. Then the court took over the questioning, asking him if he was going to waive his attorney-client privilege. He said no, and that effectively ended the evidence that I was planning on putting in to show that he had instructed Mr. Price to pay Ms. Commons her fees, and that he owed the fees, that she, laid the foundation for the whole thing by having him testify that he hired her, he did work, she did work, there was a settlement, all the things that you have to show that Ms. Commons had a right to a charging lien. None of that came in through Mr. Spracklin. It was all spoken to either in argument or testimony from Mr. Price, who was the one saying that Mr. Spracklin didn't have a dog in the fight, actually. But it didn't seem that way because there's no reason for Mr. Spracklin to refuse to testify that Ms. Commons was his attorney, that she got a settlement for him, and that she's owed fees, and that he has instructed his fiduciary to pay those fees. Yet he wouldn't do that because ostensibly he's helping Mr. Price. Mr. Spracklin stopped communicating at all with Ms. Commons when this whole issue arose. About the evidentiary hearing, the court took over, saying that she could decide this as a matter of law. When she said that ended the evidentiary portion. It's her courtroom. She can do what she wants, but that basically ended it. The pending action in Miami, the amended complaint has not even been served. That case hasn't gone forward at all.
Even if there is an amended complaint, is it in our record? It's not in our record. I don't know that we need to talk about it.
It was in the reply brief because as a response to something in the responsive brief. That's the only thing.
So
there.
it was not before the trial court.
No, at that time, it was not.
Got about half a minute, Ms. Banish.
Okay, I would just like to reiterate that Ms. Commons is entitled to be paid. There's a strong public policy that attorneys are to be paid from the fruits of their labor. That takes precedence over a retaining lien. It predates when a retaining lien could have been arisen, and we ask that the case be remanded for to reinstate the charging lien and for determination of interest on the entire amount.
Okay, thank you both very much. To leave our virtual courtroom, there is a leave button on the Zoom screen, and if you click that, you will go away.
Thank you very much.
Thank you. You see it, Mr. Gross? Oh, there you go. All right. Okay, our next case, which is the last one on our docket today, is Pagidipati versus yes.
Half of the appellants, Siddhartha Pagidipati and 1010 Capital Inc. I want to cover today 3 points. The first is the wrong standard that was applied by the trial court, the Gonzalez standard, which, although appropriate in the circumstances of Gonzalez, is inappropriate here. The Shelter Cove, the proper standard that should have been applied. And then I want to turn back to the State Farm Supreme Court case that relates to the fair and efficient administration of justice. I'd like to reserve 7 minutes for rebuttal. The first thing to confront is page 14 of the answer brief, where the appellee says that we have sought to disqualify the McIntyre firm based upon their having brought the derivative action on behalf of Mr. Vyas. That is incorrect. If that were correct, then Gonzalez would apply. But in point of fact, we filed our motion to disqualify after the amended complaint was filed. And the circumstances are a bit complex factually, but they're very important because they show the gamesmanship that is at issue here. The original complaint was brought by Mr. Vyas against my clients derivatively because the derivative statute is a creature of equity. The idea being that whoever is locked out of management of the corporation gets to sue on behalf of the corporation. And we all know that normally when you bring a derivative case, at least nominally, one of the defendants is the corporation itself. So obviously nothing about suing derivatively would set up a law firm for disqualification. And that's why we never sought that. Now, we filed a motion to dismiss the original complaint because the company had been reinstated, and under Delaware law, Florida law, you can't sue for a canceled company, canceled under Delaware law. So what they did when they saw our motion to dismiss is Mr. Vyas got together with 2 of the 3 original bunco artists that brought the Q3 fraud scam into being, and he installed himself as the liquidating agent. And that is the right thing to do under Delaware law if the company is going to wind up. Delaware statute 17.803B jibes with the LPA, the limited partnership agreement, 9.02C, to say that the successor to the general partner is going to be the liquidating agent. And that's for all purposes. He brings the lawsuit, if he wants to, on behalf of Q3I LLC. Just like if I were to bring one for our law firm, it would be Anthony and Partners LLC. I don't have to put my name in the beginning, as in a derivative case. And this furtive sleight of hand and the way the case is styled reflects some belief on the part, and ultimately it persuaded the trial judge that somehow the derivative statute still applied. But it was transformative what happened when Mr. Zayas started the case derivatively, but then he brought it directly as general counsel. I'm sorry, as the equivalent of general partner. It has nothing to do with Florida Rule of Civil Procedure 1.210. It has everything to do with the fact that we heard on the record during the dismissal hearing what counsel had done. And let's see, the day before the dismissal hearing, we got an amended complaint where he's bringing the claims in his own name. Now, we said there can't be a creditor because of X, Y, and Z. That's an element for this cause of action under the limited partnership agreement. Bracketing for the sake of argument, this LPA is part of a fraud scheme. But the bottom line is that counsel said very bumptiously to the court, we're going to be getting a default judgment. Your Honor, you know of a third case pending before you, and we're going to be getting a default judgment against Q3I for the recovery vehicle, the other plaintiff. We were sued 2 times on the same day for the same $3.5 million. So one of them was the recovery vehicle. All you have to do is see the complaint. He signed on behalf of them. And then he also signed on behalf of the de facto general partner for Q3I. Why was he so confident that he was going to be able to get a default judgment? Because he controlled both sides of the lawsuit. All he had to do was talk to Mr. Bias. He's a liquidating agent. Mr. Bias not going to show up and defend. In fact, they had the audacity, the temerity, when we moved to intervene so that Q3I could actually get a defense, to say we're going to dismiss the claims against Q3I, and we're going to dismiss them without prejudice, which means this is a live issue, but we're going to dismiss them. Never explained why. Could it be because they have a huge looming conflict and occlusive judgment was going to be obtained by one McIntyre firm client against the other McIntyre client in order to contrive a result? That's exactly what was going on. He didn't say
Anthony,
it.
let me jump in. And let me take it a step at a time.
Yep.
As you know, the standard of review is abuse of discretion, because
I don't believe so.
I'm sorry?
Your Honor, I don't believe so. In this case,
Okay.
the standard that applies is that the standard was wrong. Gonzalez should not have been applied. Shelter Cove should have been applied. You cannot apply a derivative standard when we all know that this is not a derivative case.
Maybe you're misunderstanding me. I'm just saying, I'm referring to the fact that that the standard of review for orders entered on motion to disqualify counsel is that of an abuse of discretion. That's what I'm referring to.
Well, Your Honor, I recognize that, but that's only, and that was covered in Shelter Cove, which we can move into. But the bottom line is the lack of substantial competent evidence to support that result leads you to say, number one, the wrong case law, the wrong standard is applied. But then we get to, and Your Honor,
let me then take it, because I just want to be able to take you step by step. So, and the main reason I think why we have this high standard, because everyone has the right to hire their own lawyer. That's really sacrosanct and so forth. But having said this, let's look at what was presented before the court. Okay, I want to make sure, take it one step at a time.
Very well.
In this case, as I understand the facts, and correct me if I'm wrong, that we have the McIntyre firm representing Vias in his capacity as a liquidated agent for Q3I, right? So we have that. And in that action, the liquidating agent is bringing claims in that case against, I guess, your client. So within this lawsuit, then we also have the McIntyre firm representing the, let's call it the recovery vehicle, of which Vias is still a member, right? And bringing claims against the same defendants. So the question before us and what was before the court seems to me, as I read the finding, came to the conclusion that because because the attorney, the McIntyre firm, did not represent simply the corporation, that was not hired by the corporation, focused its ruling on simply that, came to the conclusion that there was no room for disqualification. So my question to you, Mr. Anthony, is that you have to look as to what type of information the McIntyre firm would be privy to, right? To try to make a determination whether or not they would be disqualified or not?
No, Your Honor. Number one, Shelter Cove, and I recognize that's a sister court, the first DCA, that opinion came out 6 days, at least it was decided 6 days before the hearing before Judge Farfante. But the bottom line is, it is assumed that it is an irrefutable presumption. And I'm citing the first DCA because I think it's right. And I think you will have a direct conflict if you don't follow Shelter Cove. But then let me go to the facts. Let's assume arguendo that it's not de novo review because Gonzalez is clearly inapplicable. Gonzalez relates to when somebody sues because they're not in charge of the company. But for the amended complaint, he was entirely and exclusively in charge of the company. Well, now let's take a look at the conclusory and self-serving affidavit, which the court relied upon. The first 3 paragraphs say what they say. The rest of them, I didn't get paid by Q3I. Well, that begs the question. The Mansour case and the Florida Bar versus King show that all of this is irrelevant. For him to say my law firm never represented Q3I is false. It is belied by the amended complaint itself. We know what Delaware law says. We know what the LPA says. He is the exclusive agent for the company for purposes of wrap up. And that's why when you take a look at the 5th DCA in Morse, with that, they say it's the substance of this. It's not the fact that the trust is out there and that we're dealing with assignees of the heirs of the estate. The bottom line is it's a direct conflict. Now, the most important case on point is Shelter Cove. And it says, and that does deal with abuse of discretion standard, and it relates to findings of fact that were very nitty gritty. But that's a receiver. The law firm Carver Darden represented the receiver and then attempted to represent a third lien holder. And a receiver they found had enough traction for the HOA, the original client, to say that was a conflict. Now, a receiver is a lot less than a general partner or the statutory successor to a general partner, which is a liquidating agent. There's no way to get to a different result under Shelter Cove than what we're urging. And of course,
I think you misunderstood me, Mr. Anthony. I think you're agreeing with me that Shelter Cove does apply. And I think when I asked you that initial question, perhaps I misunderstood your response, or maybe you misunderstood my question. You're basically saying that you really don't need evidence and confidential information because of the presumption. And we're dealing with Shelter Cove in this case. So I guess the question for us is that the McIntyre firm basically are proceeding with 2 things. They're doing one thing, and then they're also doing another thing, which under Shelter Cove may be problematic.
And Your Honor, it's worse than that, because the truth of the matter is, when you look at the State Farm case, and then you read our appendix, page 189 to 216, and 536 to 538, you see in great detail all the labor that the law firm did to set up Mr. Vias as the sole decision maker for Q3I. And when did they do it? They did it after we filed our initial motion to dismiss to the derivative complaint. And then they came in the day before, the day after they amended the complaint, they came in and said, oh, we are very confident that our other client, that's the only way they would have been able to, they weren't omniscient. They couldn't see into the future. So somehow they must have known that Mr. Vias, their other client, was not going to defend in that case. And the most telling and really shows a bit of audacity is that then they went in afterwards and moved to set aside the default that they were pronouncing that they were going to get when they spoke at the dismissal hearing, because they figured out that they had served themselves wrong. So they appointed a registered agent, and then they said, we want to vacate the default against our client, and then we'll move to default again now that we have proper service.
Okay,
How,
but before,
and this is why
and before Mr. Anthony, before you get too far afield, I have just one question, because I think you're going to get into your rebuttal time. And Judge Northcutt, you're about to tell him that he's getting into his rebuttal time.
You know me so well. You know,
Okay.
I always say use the time as he pleases. So, but
Okay. All right. Let me ask you that, because I don't want to assume that there is in fact a conflict. Why does your client have standing to raise it? Because you're not the former client, and isn't K3I, and K3I is 3, whatever, isn't a party. I want to make sure that you address it before we lose track of time.
I appreciate your honor. The Ironstone case stands for the proposition that special informational advantage matters. And we know that they brought special informational advantage to them at the dismissal hearing. They're cooking up the reinstatement of the company that's been canceled. They're already using it, whatever it says in the conclusory affidavit that's so tersely worded as to be, these thaumaturgic incantations of, I never represented them. The note itself to 4-1.7 contemplates that in situations like this, where you're implicating the process and fairness and justice, that like the State Farm standard, a third party like us can intervene. In State Farm, you had the law firm involved was representing the husband, the wife, and the daughter. They decided that it would be easier to play the insurance company if the husband were dropped and then sued. The husband agreed to roll over to the extent of insurance coverage, and the insurance company said, what's this all about? I have to say this, your honors. My client is gullible enough to put $3.5 million into some sort of a fraud scheme tied to a cyber currency algorithm, but he is not gullible enough to think that this is a fair system of justice when counsel is cooking up a fake and collusive judgment in order to satisfy the one creditor rule and pursue a claim under this LPA. It shakes the foundations of our litigation system for me to try to explain that to a medical profession. Thank you, Your Honor.
Okay, Mr. Anthony, you have about 5 minutes to go for your rebuttal. So,
all right, thank you, Your Honor.
Okay, Ms. Jones.
Thank you, and may it please the court. My name is Jennifer Jones of the McIntyre firm on behalf of the appellee, Sanket Vias, as the liquidating agent for Q31LP.
And Ms. Jones, I want you to give you the same consideration for Mr. Anthony. All right, we talked about the Shelter Cove, and I know the trial court was not relying on that. They just thought the other case was more. Help me out. Why we're not dealing with a derivative action here? Tell me why Shelter Cove should not be followed in this case.
Well, Your Honor, it's factually very different from the instant case. The Gonzalez case is the one that's factually more similar to the instant case. So for Shelter Cove, first, I will point out that Shelter Cove agrees with Gonzalez that it's an abuse of discretion review for this court, and that's at Penn Site 226. So the two cases are in agreement on that. The second thing for me that stands out in Shelter Cove is that there was no dispute that an attorney-client relationship existed between the attorney in question and the receiver. And that's throughout the case that the court repeatedly says there's no dispute that an attorney-client relationship ever existed. And I'm at Penn Site 227. where the court said, at the hearing below, Carver Dimber never argued that an attorney-client relationship did not exist. So in that particular case, the attorney in question had represented the receiver. And then when that receiver went away, a different receiver came on, that attorney went away. That attorney came back representing a bank on the same lien that he had been charged with by the receiver imposing. So there was never a question in Shelter Cove that he, the attorney in question, represented that receiver, and that then he was coming back in the same action and representing the bank against the receiver, who was the subsequent receiver at that point. The other thing that stands out to me about Shelter Cove is that it's a 4-1.9 case. So it's a representation of a former client case. And my understanding based on the briefing and the reply briefing is that the appellants are not making an argument under 4-1.9. In fact, that would have been waived because it wasn't actually made below, that there was some sort of a former client relationship here. 231 would have been a former adversary in the recovery vehicle case, which was case number 2402. But there's no basis to say that somehow 231 was a former client of the McIntyre firm. So for me, Shelter Cove is really not on point at all, other than the fact that it involved a receiver, which is a similar situation to a liquidating agent. But the similarities end there with Shelter Cove. And my reliance on Gonzalez is more closely akin to the situation that we have here because of the relationship between the company and the derivative plaintiff that was described in the Gonzalez case. So the stockholders' derivative action is brought by and on behalf of or for the benefit of the corporation, just like the liquidating agent in this case is bringing the action for the benefit of 231. And so in that way, the two situations are aligned.
But wouldn't you agree, Ms. Jones, that at least both cases do focus on the confidential information, whether it's former or current? Isn't that what we need to look at? And if you accept that in this case, isn't there confidential information provided when that McIntyre firm is wearing these two hats?
No, Your Honor. So I'm going to try to back that up just a little bit so that we can kind of talk about how this happened. So Q31 is a partnership. It's controlled by a general partner, which is Q3 Holdings. And then it has a bunch of limited partners who have no ability to do anything with the company. Q3 Holdings is who is currently and was always in control of Q31. I heard opposing counsel's statements that the liquidating agent is a de facto general partner or a successor to the general partner or equivalent to a general partner. I don't know where that's coming from. I have not seen that in the Delaware statutes or in the partnership agreement. That the liquidating agent is very different from the general partner. In fact, it's the general partner that provided the authority for the liquidating agent to just wind up the affairs of the company. And that is in the VS affidavit that was in the appellee's appendix, starting at page 9. We included there all of the authority that was provided by the general partner to the liquidating agent to try to wind these affairs up. So the general partner is and always was still in control of Q31. There's no confidences of Q31 that somehow the McIntyre firm would be privy to that weren't actively shared by Q31, meaning Q31 sought to have McIntyre pursue this particular claim. So what happened in the with the dismissal, because again, I heard a lot of comments from opposing counsel about the fact that Mr. Thanasidis pointed out there was going to be a default judgment. That's because the complaint had been unanswered for over a year and a half. So the complaint in the 2402, which was the recovery vehicle case, the complaint sat there from March of 2020 and hadn't been answered the entire time. So there was no nefarious behind the scenes wheeling and dealing going on. It was just a matter of it hadn't been answered. So I think it's pretty clear that the recovery vehicle would be entitled to a default judgment at that point when they have declined to answer the complaint, and then again, the amended complaint when that happened. So I just, there's no special information exchange happening or confidential information exchange happening between 231 and the attorney for the liquidating agent. And I think that's really an important point, because for me, the critical issue in this is whether the liquidating agent's attorney automatically becomes the attorney for the company being liquidated. And the answer to that has to be no. And we see many examples of this. The derivative plaintiff in Gonzalez. The derivative plaintiff's attorney is not automatically.
But that's different. The derivative, as I understand it, Ms. Jones, derivative claims are a little different. We're dealing with an individual bias who's proceeding with a liquidation of this company. And forgive me, I'm going to try to make it very, I guess, basically saying his obligation is, hey, what are the assets? What are the things? I need to find out all the information in this corporation so we could figure out as a liquidated agent, where's all the money, where's the liabilities and so forth. So you have a lawyer representing him. And the same lawyer now represents the recovery agent, the company that's trying to sue in order to claim some of these assets that may be out there. So I guess it goes back to my question. Isn't there some, when I say confidential information, that the lawyer is privy to information from the liquidating agent, because he has access to all the books, all the information, all that stuff, but yet he's wearing another hat that, oh, I get to sue in order I could recover. This is where I'm having difficulties with, so help me out.
Your Honor. So first, the liquidating agent does not have access to all of that information. That's the state of affairs. There's no evidence in the record that the liquidating agent has access to all of that information. All of the authority in this case that the liquidating agent has is coming from the appointment by that general partner, Q3 Holdings.
But isn't it common sense that if you are the liquidated agent, what does a liquidated agent do? They have to go in, they're gonna have to liquidate that, go through the whole thing, setting forth, okay, what are the assets? What do we have? What it is in order for it to basically take care of all that. And so isn't that what his role is?
No, Your Honor. So in this particular case, his role is defined by a couple of things. By the appointment papers, which were attached to the VS affidavit, that defines what the liquidating agent's role is, and then also by any law that would be applying. So he doesn't have unfettered discretion to do anything. And in fact, if the general partner decided that the liquidating agent wasn't doing something that they didn't like, the general partner could fire or remove the liquidating agent. So he's much more constrained. He doesn't have what I'm hearing you describe is sort of an unfettered discretion, like a trustee in bankruptcy.
No. But so tell me, so what will Mr. Bias do? Tell me, what will, in this case, Mr. Bias will be doing as a liquidated agent?
In this case, he is suing the claim against the appellants for the return of distributions that were made to the appellants, which is required under the partnership agreement to be returned to the company in the case of insolvency.
And how about the language of the LPA? I mean, if we could look at the language itself, let me see if I could pull it.
Yes, Your Honor, I think
doesn't it say that the LPA makes clear that the liquidating agent has the powers and duties of a general partner in winding up and distributing assets, among other things, quote, shall conduct or cause to be conducted a full accounting of the assets and liabilities of the partnership. That's where I'm troubled with.
And I'm sorry, which record page are you on, Your Honor?
I'm looking at the LPA that you have that's in the record.
Okay, and which section? I'm sorry, Your Honor.
I don't know where, because I actually pulled it out and I have it in my little notes here. So I don't recall exactly where I got that from.
Okay, so.
But it's in the record, and this is the language that I got from the LPA agreement.
Okay. Well, again, I mean, I think in this particular case, it's governed by the appointment that the general partner gave to.
Oh, here it is, Ms. Jones. It's section 9.02A.
Okay. And I have 9.02C out here, so let me just make sure I'm looking at the same thing.
Yeah, it's in appendix, I think 416.
Yes, Your Honor, I've got that. Okay, so section A is talking about the dissolution of the partnership, and my understanding of where the partnership is right now is that it has not yet been dissolved. So it still exists, and the general partner is still in control of the partnership right now. So I guess maybe that's part of what the difference is. And I think for me, the problem with the appellant's position is that I think it would fundamentally change the nature of attorney-client relationships in the state, because that's a subjective determination based on what the attorney and the client intend. That's straight out of the Gonzalez case that tells us that. And in this case, what we have is we have no evidence that Q31 ever intended an attorney-client relationship with the McIntyre firm. We do have evidence the McIntyre firm never intended an attorney-client relationship with Q31. It was the burden of the moving party to provide us with any evidence that Q31 intended for there to be an attorney-client relationship. There's just nothing in the record that indicates that there was any sort of an attorney-client relationship intended or formed between McIntyre and Q31. And so if appellant's position were found to be correct, we would be fundamentally changing the way that attorney-client relationships are formed.
And I don't follow that, Ms. Jones. I don't follow that.
So in this particular case, it was Mr. Vias who hired McIntyre firm.
Correct.
Appellant's position would then say that somehow, because Mr. Vias hired the McIntyre firm, now the company that has appointed Mr. Vias to liquidate it is also a client of the McIntyre firm. Now we see this with trustees, with receivers. They each have their own attorneys. Those attorneys do not represent the company, just like with the derivative plaintiff. And I do recognize that Your Honor believes that is a little bit different. To me, they're both acting in their individual capacities for and on behalf of the entities. They both owe the fiduciary duties to the companies. And so to me, they're quite similar. So I guess I'm concerned about expanding the scope of attorney-client relationships outside of the party actually engaging the attorney and intending for the attorney to be their attorney, and then the reverse, the attorney intending for this person to be my client.
Well, and I'm not suggesting that. My main concern is Vias himself as the liquidating agent. What information is he privy to? That's when, and we look at the LPA, what is his obligation? And then he has the same attorney that's representing the recovery. I guess that's where I'm concerned. And this is where I'm coming from. I'm not suggesting changing the whole law about, and I agree that a client has absolute right to hire his attorney of choice, but we have to be careful and to make sure that no conflict arises. And this one, honestly, it just seems unseemly that we're dealing with the same lawyer, basically wearing, the two hats here, dealing with conflict. It just troubles me, Ms. Jones.
And I want to resolve those troubles for you. I guess the first thing is that there is no current conflict because the claim against Q31 in case number 2402 was dismissed. So there exists currently no conflict. That moots the issue really from a practical perspective, because there exists no current, there is no lawsuit in which McIntyre is representing a party at this point that's suing Q31. And then I guess my second thought on that is who has the ability to assert that conflict? It would have to be someone who is a client of McIntyre. So perhaps Q31, or I'm sorry, perhaps the recovery vehicle could assert that. Mr. Vias could assert some sort of a conflict. But assuming that there's this, my problem with the appellant's position is that it assumes an attorney-client relationship and then says there's an irrefutable presumption that that confidences were shared between the parties because of the assumption of the attorney-client relationship. But that the existence of an attorney-client relationship is exactly what's in dispute here. And that's where it diverges. So there simply isn't an attorney-client relationship between Q31 and McIntyre that would give rise to any sort of irrefutable presumption. And the other,
and I just wanted to correct you, Ms. Jones, because I think you said only a client could raise this. I think the Florida Supreme Court already weighed in on it, that even third parties can as well. I want to, and I know you didn't mean that, but I want to make sure to clarify that.
yes, and I appreciate that, Your Honor. There is a narrow exception to the privity requirement that does say someone can stand in the shoes of the person who would have the ability to move for disqualification. And that's the standing argument. And the appellee would assert that the appellant does not have the ability to stand in the shoes of Q31 here. There simply isn't any way for the appellant to do so. There are no shoes to stand in, as one of the cases said. The appellant may be a limited partner of Q31. That's unclear right now based on the different positions that the appellant has taken. But if appellant is a limited partner of Q31, the limited partner does not have the authority to act on behalf of Q31. So it's unclear how the appellant would have the ability to stand in the shoes of Q31. Certainly this is a different situation than that with an insured and the insurer, as was in the case, the State Farm, I believe it was a State Farm case, where the family was represented by one attorney and then the father was no longer represented by that attorney. So I suppose for me, and I know we disagree about this, Judge, but I believe that the Gonzalez case is controlling here, is more similar than the Shelter Code case. And again, I would point out that Shelter Code, there was no dispute that the attorney represented the receiver and that there was an attorney-client relationship there. Shelter Code was a former client case, a 4-1.9 case, which has not been raised below here, and that argument was waived. So I don't believe that Shelter Code is more applicable in this case than the Gonzalez case. And for those reasons, the appellee would respectfully request that this court affirm the trial court's ruling denying the motion for disqualification brought by the opposing party on abuse of discretion review.
Thank you, Ms. Jones. Excuse me. Mr. Anthony, 5 minutes for rebuttal.
Yes, Your Honor. I would read verbatim if I was going to lose time on it. And also if Judge Kuzum had not already covered 9.02 sub A and sub C, make it very clear. There's no general partner anymore. And 2 of the 3 hoodlums who perpetuated the fraud scheme got together with Mr. Vias and the McIntyre firm to install him as the successor. That's irrefutable. Now, I view the arguments that I've heard askance because if we were here on a Chapter 90 issue talking about attorney-client privilege, I feel pretty confident that counsel would say there's an attorney-client relationship here. But right now, for expediency, she says there isn't. We identify, in fact, counsel conceded in her, she said, well, in a receiver, it would be different. Well, this situation is different. It is more obviously an embodiment of the company, and the Delaware statute makes it very clear. Elon Musk does not have to sue on behalf of Tesla. It's just Tesla. They contrived the style of the case to make it seem otherwise. As far as the conflicts, my client, theoretically, let's put it clear. My client put in 3.5 million. He took out 3.5 million. He did not lose money. He did not gain money. And that's the reason why we're here. But the specific reality is, if theoretically our client gave up money in connection with, for example, the recovery vehicle case, he'd be unable to receive it back at pro rata in the Vias case, which would be for all 150 victims. So there's an obvious, we got sued on the same day, May 1 of last year. We got sued for $3.5 million for two clients, both represented by the McIntyre firm. They didn't file them in the alternative as two plaintiffs. They were assigned to different circuits. All of this taints the situation. This is why we have a Ken Air situation, why changing horses and wearing different hats, whatever you want to call it, there is a gross and palpable conflict that was contrived in order to give a cause of action some legs where you needed to establish the existence of a creditor. And they could not have done that unless the McIntyre firm were shepherding it on both sides, holding up one client as the plaintiff and pushing down the other client to obtain a default judgment. And when they realized they hadn't served him right the first time, they served him the second time, removing any doubt, and it's in your record, removing any doubt. They said, and we'll move for default again now that we got him served right. And to say that that's not a current conflict when they dismissed 6 days before the disqualification hearing and said, we're dismissing our claims against Q3I, that's performative. That proves what we had suggested all along. Thank you, Your Honor.
Okay. Thank you both very much. In order to leave, you press the leave button on your Zoom screen, and we'll see you guys again another time. Okay, that concludes our docket for today. The court was adjourned.